Good morning, everybody, and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. I say good morning. I know it's not morning everywhere that we're speaking to everyone, but hello and welcome. Thank you for joining us for a couple of hours this morning. It's morning where I am, at least. So good to see so many faces and so many people already in the chat. Noni's Baloney, good to see you. Lisa J, Real Happy, Farm Girl, good morning, everybody. This is going to be a good one. This is going to be a really good one. Before we jump in, let me just introduce myself because I know we have a lot of new faces and new names in the chat. My name is Joshua Ritter. I am a former LA County prosecutor. I was there for 10 years. I left the office and went into private practice as a defense attorney. And the whole purpose and mission behind Courtroom Confidential is we're hoping to provide you with a perspective from both sides of the courtroom. And we hope that we do that. And we hope that we bring that kind of energy to the community that we have built here. And we are so thankful for that entire community. So, I should also say hello to everybody in the replay crew, because we know that we have a bunch of folks who check us out after we do the live. All right. Before we get started, we got to do one thing. If you haven't already, please like this. Let's get that algorithm going. If you haven't subscribed already, please do. I think you're going to really enjoy what we have in store for you this morning. Lots of calls. You guys showed up. So I'm going to try to get through all of these. And so I'm going to move kind of quickly to make sure that we give every one of these questions the attention it deserves. So let's just jump right in. And we got something special for you too, because we got so many different calls coming from so many different places that I'll show you the little treat that we put together. But first, let's go to this first call. And Kaylin, I'm going to do my very best to not mess it up from the very beginning. Uh-oh, what did I? Okay, let's see if this works. No. Incredible. You would think we got this figured out by now. Bear with me, guys. Sorry. There we go. I had to remove the other thing, Kaylin. Sorry. That's where I think I messed up. Okay, now tell me if you can hear this.
Hi, Josh. It's Nicole from New Zealand. Could you look at the Robert Brooks case where the Marcy correctional officers who were charged with his murder and some with manslaughter were recently offered plea deals? I think it's outrageous, and I'm wondering your view as a former prosecutor, just why this is happening. Cheers.
First of all, thank you so much, Nicole, for calling in from New Zealand. So now we've got a map. We're going to put everybody up wherever you're calling from. So our first call is from New Zealand, kicking us off. Thank you so much, Nicole. Nicole brings up a case that is really serious and really important and really disturbing. But this is about the case that was out of New York involving 10 correctional officers. This is back in December of 2024. These 10 officers here at the Marcy Correctional Facility in Oneida County, New York, they went about beating up an inmate by the name of Robert Brooks while he was restrained. And if you've seen some of the video of this that they've released, it's incredibly disturbing. It's really, really horrific stuff. Well, Nicole asks, why is it that they've been extended plea deals, and what does that mean? And Nicole brings up a great point, because we hear this plea deal, and sometimes we might get the misimpression that that means favoritism, or that they're somehow getting some sort of benefit. A plea deal, though it's got the word deal in it, isn't necessarily always a good bargain, put it that way. Every case is entitled to some sort of plea negotiation. If we didn't have plea negotiation in cases, the entire works would come to a screeching halt. The entire system would collapse. There are just far too many cases in our system for every single one of those to go to trial. So you have to, and nobody's going to plead to exactly what they're charged with, because what's the benefit in that? They might as well go to trial at that point. So we have this plea negotiation. We have this idea that the way to keep everything moving along is that sometimes we're going to have to offer deals to people. And a deal, even though I keep on using that word, not always necessarily deal. Sometimes it's plead to the entire sheet and I'll make sure that you don't go to prison for the maximum. Plead to a lesser crime, whatever it is. It's some sort of, oftentimes some sort of benefit, but not necessarily meaning that that person's going to get off or be out of prison. So these 10 officers were offered plea deals, which is how it takes place in every single case. The details of those offers have not been described in open court, so we don't know what they are, but one of their attorneys said it was essentially plead to manslaughter for a recommendation of low term. So that's what they're charged with, is manslaughter. So the deal isn't all that much of a deal, really. It's plead to what you're charged with, and we'll recommend, by the way, no guarantee to it, we'll recommend that you get the low term on the end of your exposure for prison. So great question. And I think it clears up sometimes what we might think of as a misinterpretation of what a plea negotiation actually means. Sometimes it's no benefit at all. It's just a way for them to avoid a far worse situation if they actually head to trial. But a really awful case. And we hope that there is some resolution on that whole thing. But great question, Nicole from New Zealand, starting us off. All right, let's move along here.
Hi, Josh. This is Jen M., long-time lurker. You've probably seen my messages here and there. I don't particularly have any questions on current cases. However, I am from Fall River, Massachusetts, home of the Lizzie Borden case. And the attorney's office who originally did her defense is still in practice, and they are still holding all of her court records, and they're not releasing them due to attorney-client privilege. Does that attorney-client privilege ever end? I'm just curious because she's been deceased for so long. Thanks so much.
Jen from Fall River, Massachusetts. I love this. I love this question. This is exactly why I love this show. There's Fall River. Thank you for calling in. I never in a million years would have thought, you know what? Let me tell people about what's going on with the Lizzie Borden case. But thank you, Jen, for bringing this up, because it does have a fascinating element to it. So if you don't know about Lizzie Borden, there she is. This is the OJ case before OJ. This was the crime of the century before the crime of the century. This took place. She was tried and acquitted in 1892 in Fall River, Massachusetts, for the axe murder of both her father and stepfather. And the reason many people still know about it, one, it was kind of a famous older case in true crime, but there's also a nursery rhyme about it. And I read the nursery rhyme to Kaylin this morning, and she gives me a look like I've never heard that before in my life. I don't know what you're talking about. But Lizzie Borden took an axe and gave her mother 40 whacks. When she saw what she had done, she gave her father 41. And then Kaylin asked the wonderful question, why in the world does it seem like all these nursery rhymes have a really twisted and awful background? And it's true. I don't know why that is. And I don't know why we sing these to our children. But anyhow, Lizzie Borden accused of axe murder and acquitted. Now, here's where things get interesting. Her attorneys, not the actual attorney, but the law practice of that attorney, who has long since died, is still active today. That firm still exists, that the attorney that represented her, and they still have many of her documents, which is incredible. and they're refusing to turn them over or do anything with them. Now, nobody's asking for these things out of, trying to reinvestigate the case. It's more about historically, perhaps adding them to a library, a museum, or something like that. And they're saying they're still asserting privilege over this. So it begs the question of how long does attorney-client privilege survive, and how does it survive the death of the client? Interestingly enough, this was considered by the Supreme Court. Swindler and Berlin versus the U.S. in 1998. This was part of the Whitewater investigation into President Clinton. And there was a quote in that case that says clients may be, this is why they consider that the attorney-client privilege survives even the death of the client. You may wonder, well, what do they got to worry about if they're dead? Why do we need to protect any kind of communication for a now dead person? Because it's the client, it's the defendant who is the holder of the privilege, meaning they get to decide when or when not to waive that. And if they're dead, what's the point? The Supreme Court says clients may be concerned about reputation, civil liability, or possible harms to friends or family. Posthumous disclosures of such communications may be as feared as disclosure during the client's lifetime. So, to answer your question, Jen from Fall River, where Lizzie Borden was from, it does survive, and it still survives. And the answer of how long does it survive is kind of unanswered. It's each state has some litigation pertaining to some of it, but usually it has to do with the estate of the deceased and whether or not you want to waive privilege to understand what they intended to do with their will, not did they confess to axe murdering their parents or not. So a very, very interesting question. And the answer, one last thing on this, I should say, if these attorneys were to turn those papers over to a library, even though that would be breaking attorney-client privilege, you got to think about who's harmed at that point as far as suing anyone or trying to prevent them. So you may see instances where these types of things are disclosed decades and decades down the line. But thank you so much, Jen from Fall River. All right, let's get it moving along here to our next question. Love this so far. I love.
Hello, Josh. This is Carmina from Valencia in Spain, and I just wanted to know your opinion about the future of the Menendez brothers now that the new DA is asking the court to withdraw the motion for resentencing. Do you think that they have lost their last chance to get out? Thanks so much. I really love your show, and yeah, have a good day. Thank you.
Carmina from Valencia, Spain. Throw it up on the map. Look at this. Already, Courtroom Confidential Airlines is getting their frequent flyer miles, and we've been to New Zealand, Fall River, and now over to Valencia, Spain. Loving this new map. Thank you, Kaylin. All right. She asked a very interesting question about the Menendez brothers. They were recently back in court on Friday, and she wants to know, Carmina wants to know, is this their last chance to get out? And I've been following this case very closely because if you live here in Los Angeles, I've been on ABC 7 nearly every time it's back in court. They've been gracious enough to continue to have me back, so I make sure that I stay on top of this one. What happened on Friday was a little bit of a twist in a case that already has more twists and turns than a cheap garden hose. And here's what took place, is that we thought they were going in on Friday to have this issue about resentencing finally decided. In fact, no, what was happening is the judge was only going to decide whether or not the current DA, Nathan Hochman, can withdraw the previous DA's, George Gascon's, position on resentencing. George Gascon said, I want them resentenced. Nathan Hochman says, nope, I don't feel the same way. And so he was asking to withdraw that prior position. What happened on Friday is the judge said, no, I'm not going to let you withdraw it, which is interesting because now you have a position paper, a motion written by a DA's administration who no longer exists and no one to defend it. You've got a current DA who says, we feel differently about it. And then you've got the defense saying, please, please let him out. So it's a mess. It's always been a mess, but we are heading back on Thursday to decide whether or not they will be resentenced. But to Carmina's question, what are their chances And is this their last chance? The resentencing is their very best chance, I think. And on Thursday, the judge will decide whether or not they will be resentenced. Resentencing just means that they would be eligible for parole, not immediate release. So it could be a while before they even get up to the parole board and before a parole board actually says, we want to parole them. So that's question number one. Track number two is clemency. And then Governor Newsom has always had clemency available to him. And he's, for some reason, just kind of sitting on his hands, waiting to see what will happen with this whole case before he decides what to do. But even if they are denied resentencing, they can still be granted clemency by the governor in California at any point. And happy early birthday to Kale. Thank you so much. Happy birthday to you. And then finally, there is the petition for a writ of habeas corpus, which is kind of what got the ball rolling on all of this. And I think the chances of that are very, very slim. So, Carmina, to your question, it's kind of a wait and see. If they get denied, if their best chances for Thursday, if Thursday they are denied resentencing, their chances slip to then just hoping the Governor Newsom wants to take a chance and grant them clemency. Mama She says, happy to spend some of my B-Day with all of you. Oh, it's your birthday today. Well, happy birthday to you, Mama She. Thank you so much for being here. All right. I'm loving this. I'm telling you, we're hopping all over the world, and we're hopping all over the world of true crime too, because I never would have expected these questions. Let's keep it going.
Hey, Joshua and crew, it's Alicia K. Mayo from West Tennessee. Could you please explain what the phrase not testifying to the truth of the matter means? Because I thought everything in a trial was supposed to be the truth. And I'm going to put you on the spot a little bit. Joshua, rate Lori Vallow Daybell as an attorney. Thanks. Happy Sunday. Bye.
Oh, Alicia K. Mayo, thank you so much. Always love hearing from you from West Tennessee. Put it on the map, Kaylin. Great question. So first she wants to know, what does this mean when they say not testifying to the truth of the matter? The phrase is whether or not something is being testified to the truth of the matter asserted. And what this has to do with is hearsay. Hearsay is an out-of-court statement made for the truth of the matter asserted. So what does that mean? First of all, it's a statement that has to have been made out of court. So somebody said something prior, somebody said something anywhere out of court. I mean, it's pretty self-explanatory. The second part is where things get a little interesting, is are you trying to introduce that statement to prove the truth of that statement? And that's essentially what that truth of the matter asserted means, is if someone says Josh shot Joe, well, I'm doing this wrong. If someone says Kaylin told me that Josh said he shot Joe, okay? And that person wants to testify to what Kaylin said. Well, they're testifying to an out-of-court statement. And if this is a murder trial for Josh, they want that brought in for the truth of it, that Josh admitted to the shooting, okay? But you can't bring that in if you're trying to prove the truth of the matter. If you're saying that someone said, I heard Kaylin say, it's so hot outside, I feel like I want to die. Now, that's still an out-of-court statement, but do I really want the truth of the matter that Kaylin wants to die? Or is this just rather an expression of her reflecting upon the heat of the day? And does that therefore make it not hearsay? And because of that, there's a bunch of exceptions to hearsay. Present sense impressions, dying declarations, talking about somebody's internal motives as to what they do next, all sorts of things. But the biggest one you ever hear is attorneys almost immediately go, it's not being offered for the truth. So we want a statement to come in because we're not trying to actually prove the truth of that statement, but it's for some other purpose. Anyhow, you could talk about hearsay all day long. Alicia, it's a wonderful question. Let's get to why are excited utterances not considered hearsay? Hearsay is about reliability. So hearsay is about, can we believe this out-of-court statement? Because that out-of-court statement is not subject to cross-examination. So therefore, it's inherently unreliable. But what are some statements that could be made outside of court that might contain some reliability? Well, we've decided that an excited utterance, in other words, something that's said in the moment of kind of reaction to something, oh my God, he just got shot. That carries some inherent reliability to it, and we will allow that statement to come in under an excited utterance exception. We could talk about this, like I said, for hours. It's a fascinating topic in the law and something that most lawyers don't understand. Speaking of bad lawyers, let's talk about Lori Vallow. Her second question was, how is she doing? I will say this. She is doing better than I thought. I thought we would be having the wheels come off way earlier than now. She's, listen, I think she's going down in flames, but she's doing a serviceable job. Put it to you this way. I've seen attorneys do a far worse job than what she's doing. So she's getting up there. She's asking questions. I'll tell you where she's starting to really crack, though, is when it's coming down to how personal this whole thing is for her. And it obviously is. And that whole, so you spent your whole day talking about me, and why am I blanking on her name? Nora Jo Hancock, and not Nora Jo, something Jo, Nancy Jo Hancock, saying, don't flatter yourself. That moment right there, I think, really shows where the cracks are going to start to form for Lori Vallow. Is she cannot help herself but take this whole thing personally, and she's just going to turn it into her personal kind of airing of grievances. Other thing I think will take place is I think she's going to view this forum, the courtroom, as a pulpit. And I cannot imagine her getting through this whole thing without her bringing her religious views into this. Lori is a hot mess. And what do we know about a hot mess is that is basically a dumpster fire, because that's what you get when you light a dumpster on fire. All right. Let's keep it going. Alicia K. Mayo, love to hear from you. Thank you for calling from West Tennessee.
Hey, Josh, this is Amanda, Super Planner Girl again. And I just had a question regarding a time that I was seated for a jury a couple of years ago. And I've actually really wanted to speak to a lawyer about this ever since it happened. So I had gone through, the initial questioning, and then they were calling us up to a podium one by one. And they were asking me, the typical stuff. What do you do for a living? And kind of tell us some of your background and things like that. And then kind of out of nowhere, they asked me back in some number of years ago, I think it was like 2011, 2012. I don't really remember exactly. They were like, did you have a conviction for such and such a crime? And it gave me pause. I will admit, I was like, what are you talking about? And the only thing I have ever had in my criminal history is a traffic violation, like a speeding ticket. And so I quickly recovered my surprise, I guess, and was like, no, not at all. And they carried on, and I was seated for the jury. And so my question to you is, like, why would they even say this at all? Like, what's the point? Were they trying to throw me off, gauge my reaction? I'm just completely, have no clue. So I'd love your perspective. Thanks.
Thank you so much, Amanda. Amanda, I love your question. I just wish we knew where you were from, because we're adding to a map here this morning, Amanda. But thank you so much for calling it. If you're listening, tell us where you're from. Mama She says, I can't give memberships from my phone, but love to you all, and thank you all for the B-Day wishes. Oh, well, thank you, and happy birthday again, and thank you so much for all of your support. Really interesting situation, Amanda. I will say this. One, I do not believe they were trying to throw you off. I don't think this was some sort of sick game to kind of get in your mind as a prospective juror to see how you would react to it or admit to some sort of crime you never committed. One thing that would be interesting to me to know is what kind of a case was this? And the second thing is what jurisdiction are we talking about? But I think more than anything, what may have happened is, in many jurisdictions, though the jurors remain anonymous, on the record, many times the attorneys are provided with the names of the jurors. So in California, we get a list and it's got everybody's name on it, but we just never refer to anyone by their name. We just refer to them by their juror number to keep everything anonymous for the public and on the record. But if a prosecutor had the time and inclination, I suppose he could run a criminal background check on every single person on that jury list. And maybe that's something they do in that jurisdiction. And maybe your name came up for some sort of warrant because somebody shares your name who got into trouble. That's the only thing I can think of. Not an uncommon thing, by the way. We used to get these all the time where people would come in and they would want paperwork for a bad name, that their name got wrapped up in having some sort of warrant, and it's not them, it's somebody that shares their name that committed this crime. So they would need to get fingerprints done and some sort of paperwork to clear them. So Amanda, that's the only thing I can think of, but that's a bizarre situation that I have not heard of before. And the other thing too is that usually people are even disqualified from receiving a jury summons if they've committed a crime. So thank you so much for Amanda for calling in with that question. Appreciate you. All right, let's move it along here.
Hey Josh, this is Ashton out in Arizona. I'm usually catching you on a replay, so hope to see your Sunday fun day and see my question. So my question is a more broad, not necessarily on a certain case, but when it comes to choosing what charges to bring against the defendant, when to bring those charges, when to arrest them, who all is involved in that conversation, and what does that room look like? Thank you.
Hello, Ashton from Arizona. Great question. Let's put you up on the map, first of all, calling from Arizona. Appreciate that. Ashton asks, who is involved in making the decision to bring charges and an arrest? Let me first say this. The vast majority of cases, this is how it takes place. Either police witness a crime taking place and they arrest someone, or police are called to a crime scene by someone who says, that person just robbed me. They arrest a person, and they book that person under potential charges, and then they bring that potential case to the DA's office. And the DA's office then sits down and decides, was a crime committed here based upon what the police are telling me, what's in the police reports, the evidence that we have in front of us. And then the DA will bring charges based upon that. And that person who's now been arrested has been sitting in jail for no longer than 48 hours. In different jurisdictions, it's different. In California, it's 48 hours. And then they have to be arraigned on those charges. So then they're brought into court and they're told what they are formally been charged with. So that turnaround between arrest and charging arraignment has to be about 48 hours. That is how it's done in 99% of the cases. Police investigate, police arrest, police bring it to the DA's office makes a decision. In bigger cases, it's all done very differently. Let's say you've got a case where you have a string of assaults, a string of murders, a string of robberies, whatever it is. And now you're bringing all sorts of cases from different jurisdictions to the DA. Well, then you might have the investigating officer sit in. Thank you so much, Leslie, for joining us. You will have the prosecutor. Maybe you even have the prosecutor's head deputy. Maybe you have all of those different agencies come in, and you're going to make a decision on what to bring and how to bring these charges. And that can sometimes be a complicated decision. Sometimes that decision is made after the person has been arrested and charged with something less serious. Let's say you pick up somebody for a residential burglary. You have them, you've run their fingerprints, and now you realize that this person is not only good for that res burg, they've also committed 5 other residential burglaries that ended up with home invasion murders. And so we're going to charge this person with 5 murders on top of this burg. So you charge them with a residential burglary, you keep them in custody while you're then deciding what do we do about all of these other cases that we've matched through fingerprints or DNA or what have you. Then that gets even more complicated when after murder charges have been brought, are they going to seek some sort of enhanced penalty? Are they going to seek the death penalty or life without parole? then it might go to a special committee within the DA's office. And at that committee, they will have presentations, and they will have investigators and DAs and even the defense attorney perhaps submit some documents to talk about whether or not this case should in fact become eligible for the death penalty. So a lot of thinking goes into it in these very important types of cases that are very complicated or very serious. And then a lot of it also depends on how quickly do they have to act. So like I said, police see a crime taking place in front of them, they can make an arrest. But if a crime is reported to the police later on, maybe they bring that information to the DA, and now the DA files a complaint, a criminal complaint for warrant, meaning that person's still out. I'm bringing these charges, go out and get him. We're filing the complaint, now go out and find this person on a warrant. Or if they have to even move more quickly, in other words, the police cannot arrest someone without either a warrant or witnessing the crime. So if they haven't witnessed the crime and they need a warrant and they can't wait for that warrant to come from the DA's office, they can go directly to a judge and say, Judge, here's an affidavit. Here's everything we know took place. Give us a warrant to go out and arrest this person. And that is called a Ramey warrant. You may have heard that referred to as well. And the police will go then out and arrest that person, bring that person back in. But ultimately, in all of these situations, the charging decision has to be made by the DA. There is the longest and most in the weeds, complicated answer to a very simple question. And I hope I didn't lose you all already. Have a sip of coffee. I hope that woke you up. Do all felonies go to a grand jury first? No, but it really depends on the jurisdiction. In places like Massachusetts, everything goes through a grand jury, is my understanding. In places like California, the vast majority of things do not. They go through a preliminary hearing. So they'll charge someone, and then within 10 days of that or longer, they will have a preliminary hearing to decide, is there probable cause to keep this person locked up and answer for trial. Every state has some sort of probable cause determination. Each state is different. And in some, it all goes through grand jury. In California, there's just way too many cases to put everything in front of the grand jury. So we do it by arrest, by complaint, and then everything goes through a prelim. So anyways, and the grand jury can indict a ham sandwich. That's a very, very famous kind of quote, because grand juries are a little prosecution friendly. Put it that way. We could get into that more later. If you want to know more about grand juries, call and leave a message at thecourtroomconfidential.com, and we will happily answer that at our next Sunday Fun Day. But thank you so much, Ashton from Arizona. All right, let's keep it rolling.
Hello, everybody. Hi, Josh and team. What exactly are motions? Oh, by the way, this is Brooklyn Janet from Boca Raton, Florida. What exactly are motions? There were a lot today in the Bryan Kohberger case. Can both the judge and the defense bring up motions? And wouldn't the personality and the biases of the judge affect their decisions on the motions? For example, Judge Bev in the Cameron Reed case seems to favor the state, in my opinion. I just picked that up a lot. Therefore, certain things probably wouldn't be allowed or would be allowed in the case. So it's interesting how a judge can really determine how a case goes. All right, your opinion on that, Josh, and any examples you might have. Okay, I think that's it. First of all, thank you all for making my time listening enjoyable and exciting. I appreciate that. And Josh, a word of advice. You treat Kaylin with kid gloves. She's very special. You be happy.
Janet from Boca Raton, Florida, thank you so much for calling in. And Gisela, thank you so much for wishing us all a happy Sunday. So good to see you. Kaylin from Boca Raton, pardon me, Janet from Boca Raton. Kaylin do you have something to do with this? Did you get, is Janet a plant that you got her to call in? Oh, Janet, believe me, I'm scared to death of Kaylin, and the only reason I can talk tough is because I'm looking at her through a screen and I know she's several thousand miles away. But thank you so much, calling in from Boca Raton. Excellent question, and you're right. Kaylin is a gift, and we appreciate her immensely. Janet's asking, what the heck are motions? I love this question because it's like we assume some of these things are just given. What is a motion? And the more I thought about it, that's not the clearest answer in the world, but the basic answer is a motion is just a request of the court to do something. You're asking the court, you're asking for the court to, you're moving the court to make some sort of decision on something. It could be about evidence. It could be about witnesses. It could be about continuing the trial. I mean, everything that you're asking a court to give an order on, give a ruling on, is essentially a motion. They can call them different things. They can call them motions. They can call them requests. They can call them, orders to show cause, whatever it is. But all of those, I think, fall under that greater kind of umbrella of a motion. And motions can take different forms. She brings up the Karen Reed case. Karen Reed, in Massachusetts, things are done very differently than they are in California. And they are very formal with everything that you want to do has to be written down in some sort of motion. I want to call this witness. I want to challenge that witness. I want to, bring up this argument. I want to challenge that argument. Whatever it is, it has to be in some sort of motion form, written down, filed with the court, copy served on the opposing party, and an opportunity to have oral arguments and be heard in court. In California, well, especially here in Los Angeles, a lot of this is just done shoot from the hip in court. We will head to trial. This is how things go in the vast majority of these cases that are not, making national headlines. You get sent out for trial. Are both sides ready? Yes, Your Honor. Yes, Your Honor. They say, great. Report to Department 102 at 10:30 to begin jury selection. You report to Department 102. That judge has never heard of your case before. The judge is taking a look at the file for the very first time, realizing, okay, you've got a murder case here. And then the judge will say, what motions in limine do we have? And then you sit down and you argue, hey, they want to do this. We don't want to let them do that. They want to call this witness. We think that's inappropriate. And you just argue these things without filing a bunch of paperwork. You're just arguing it, shooting from the hip in court. Judge makes a bunch of decisions. You realize the lay of the land. And then by 11 o'clock, you've got 80 people, 80 strangers who don't want to be there staring at you. And you're trying to explain to them why they got stuck with jury duty. That is how most of these cases go. In your far more serious cases, you're going to see the type of motion and law work that you see in the Karen Reed case. But everything's public. Objection case says, our motion's public. Everything's public. Every once in a while, they might close the courtroom because, maybe a child is testifying or something like that. But everything is public. You can walk down to any courthouse, walk in and see some really awful lawyers arguing some really boring motion anytime you want to. Janet from Boca Raton, who is obviously a plant by Kaylin. Thank you so much for calling in. Appreciate you. All right, let's keep it going here.
Hi, Josh and CC team. My name is April, and my question isn't about a specific case, but rather the legal profession. I'm curious about how an attorney's mindset changes when switching from careers from a prosecutor to a defense lawyer. What motivates someone to leave one role for the other? I'm sure the drive and focus remain the same, but is it a difficult transition? Do you feel more liberated because you can choose whom to defend? Also, do you find one role more fulfilling than the other? That's all for now. I love hanging out here. Thanks, guys, and cheers from Nova Scotia.
April, thank you so much. Our first caller from Canada. So let's throw Nova Scotia up on the map. Appreciate you calling in, April. Love this question. I'll just tell you my kind of version as to hopefully answer some of this. I wanted to be a career prosecutor. I loved it. I loved everything about it. I loved feeling like you're doing, the Lord's work. You're feeling like you're the good guy. You're putting the bad guys away. You're protecting people. The majority of cases that you're dealing with are not close call type cases. They're really, really bad folks who've got a criminal record a mile long, who've done some awful things, and you're trying to set the world right. And I loved it, but it's government work, and you are a cog in a very large machine. And I began to get frustrated by, there's very little attention given to kind of your career ambitions. And I began to feel a little frustrated by that. And I began to feel a little stuck, and I was stuck in an assignment. And the only reason I was given for that was, budgetary reasons. They needed to promote people above me before they could promote me, and they didn't have the money to do it. So I got stuck in an assignment, and I got a little frustrated and maybe overly anxious about all of that. And I just remember being like, this is kind of stupid and a bureaucracy. And I remember people telling me, hey, we would love to have you in this special assignment, homicides and gang cases and everything else. But, you got to get that promotion, and you can't get the promotion because of the budget. Anyhow, along the way, Alan Jackson had left the office. Alan and I stayed in close touch, and Alan said, are you ever thinking about leaving the office? You let me know first. And that kind of planted the seed. And before you know it, I was thinking about leaving the office, but it had nothing to do with not loving the work, and everything to do with just kind of wanting advancement in my career. And quite frankly, money wasn't a bad thing either. I will say, from a kind of emotional, maybe that's not the right word, but kind of an internal compass perspective, I struggled with it, because I thought, how am I going to defend these people? And that's what you hear people all the time say. How do you do that? And I struggled with that, because I thought, boy, I don't know how I'm going to feel about all of that. And then I quickly realized that nearly all of the clients that we dealt with are good people. They're really good folks who just made one colossal mistake in their life. And maybe that was drinking a little bit too much. Maybe that was getting a little too greedy. Maybe that was getting, making some sort of a mistake that was an anomaly in their life. Some people are bad, and we can say no to those people. Other people are great folks. A lot of these former clients are now friends of mine. They've been to my wedding. They're good people, and they just made some mistake, and it's a mistake any of us could make. And I quickly realized that, wow, this isn't really about good and bad, black, dark or white here. It's about just trying to do the best you can in the role that you have in this overall system. And so that's the way that I started to view it, is that I am still involved in law enforcement. I'm just making sure that the laws are enforced against the government, and that my clients are being protected, and that I'm doing the best job for them that I can. As far as it being fulfilling, it's fulfilling just in different ways. You've got people who are incredibly grateful for what you've done for them. And, when you're in the DA's office, you had a kind of gratitude, but it might not come from the same folks. So very good question, April. Did I work with Emily D. Baker? I did not work with Emily. I know Emily, obviously, now. And I have friends who worked with her. This is Nasha Jones asked this question. The DA's office in Los Angeles, little fact for you here. The DA's office in Los Angeles is the largest prosecutorial agency in the world. Los Angeles County is enormous. And the LA County DA's office had, at the time I was there, over 1,000 attorneys, not including support staff. So over 1,000 attorneys. It's huge. New York breaks it down by borough, so they're even smaller than Los Angeles. So it's the largest prosecutorial agency in the entire world. So 1,000 different attorneys. You got to know many of them, but Emily and I were never assigned to the same assignment, so we didn't kind of overlap. But I do know people who worked with her, and all have really great things to say about her, and I hope she has heard the same about me. But thank you so much for that question. All right, let's move it along here.
Hi, Josh and team. This is Rachel from York in the north of England. Quite new to your channel and mostly been lurking, but really enjoying all your shows. So I have a question about how you would feel about prosecuting or defending a case for something that happened a really long time ago. And what made me think about it recently is Russell Brand has just been charged here with sex offences for events that allegedly took place between 1999 and 2003, I think, or maybe 2005. I don't remember exactly. But anyway, a really long time ago, over 20 years ago. I don't understand how, if those things weren't investigated closer to the time, how there would be any actual evidence. And would it just come down to, in court, one person's word against another? Which, given it's so long ago, I mean, you might not even remember half the things that happened. I don't know if this happens in the States. You have the statute of limitations there, which we don't really have here, apart from for really minor offences. So I just wanted to get your thoughts on that. How do you feel about it? And how would you go about approaching something like that? Thanks so much. Bye.
Rachel, thank you so much. Rachel from York, England. Put it on the map, Kaylin. Thank you so much for calling in. Great question. First of all, do you guys like the new shirt? This is one of our brand new shirts that's going to be coming out soon. What is this color called, Tiff? I'm not sure. I call it purple, but I'm sure she's got a different name for it. But I forgot to mention lilac is what Kaylin tells me. It's called lilac. A bunch of new swag that we have coming out for you guys. And this reminds me, don't go anywhere because we have a big announcement at the end of the show for a brand new project that we have for you guys. Yes, lilac, says T-Suze. Thank you, Tiff. Great question, Rachel. So stick around. Don't go anywhere. Big announcement at the end. Rachel from York, England. Great question about Russell Brand. So if you guys have not heard, this is what happened. Russell Brand has now been accused of the R word, indecent assault, and sexual assault in England for cases for 4 different women, as I understand it, for cases from 1991, 2001, 2004, and 2005. So even the most recent of which being 20 years old. He is not currently in England. He is still in the US. And so there is even a question about whether or not extradition may take place. When is he going to go back to England to answer for these things? Is he have plans of going back there? But in any case, he has a court date coming up on May 2nd. And Rachel brings up the question of what are my thoughts on both prosecuting and defending these older cases? Well, first of all, let me say this. If the prosecutors can prove a case and it does not fall out of the statute of limitations, which even in the US, this type of case would not fall out of it. If it's this, the charges are this serious, it likely would not, I should say. I say go for it. If you feel like you can prove it, then that's the job is about not, oh, well, it's been too long. The job is about, can you prove it? And if you feel like you can bring the evidence and you can bring the witnesses and you can prosecute a case beyond a reasonable doubt. And that is always the filing decision, by the way. The filing decision isn't, well, let's give it a chance, or, well, these people deserve their day in court. That is not it at all. That is not it at all. Do they deserve to have their story told in court? That is not the question. The question is, can you prove this beyond a reasonable doubt? And if you can, then go for it. CJ says, I'm fed up with the abject mistreatment of women. Enough. I agree. And so if they can prove this beyond a reasonable doubt, I don't care how old it is, bring the charges. But these types of cases are not only difficult to bring to begin with, because they are many times a he said, she said. These are not cases committed out, crimes committed out in the open. There are very few eyewitnesses to these types of crimes. You're talking a case 20 years old, forensic evidence, DNA evidence, other types of scientific evidence may be long gone if it ever existed at all. So they're going to be incredibly difficult to begin with. And then, yes, memories fade over 20 years. Corroboration fades. Other witnesses' memories fade. Videotape, audio, whatever else you might have to corroborate this may be long gone. So what do you do with these types of cases? We don't know, obviously, what the charges are, other than, we know the charges, but we don't know the underlying circumstances, and we don't know what they have to support all of that. But I will say that I am not shocked that this isn't one single case. And I think the fact that it is 4 different women may be part of the reason why they decided to bring this, because when you have more than one victim, you start to have elements of cross corroboration. And I'm not sure of the laws in the UK, but I know here in California, there's a very powerful law called Evidence Code Section 1108, which allows for the argument to be made that if you believe this person committed this crime, this kind of sexual related crime, you can believe that that person has the propensity to commit that crime. And if they have the propensity to commit that, then they likely committed the other crimes that they're charging them with. It's an incredibly powerful law here in California that allows for these types of cases, and especially when you have more than one charge. So if this were being tried here in California, I would say the chances of it are perhaps better than not that they'll be able to prove it, even though it's very old, because that cross corroboration starts to set in. Jurors naturally do the same thing we all do. When they hear one case, they go, "That's horrible." They hear 2 cases, they go, "Well, gee, that's strange." They hear 3 and they go, "What are the chances?" And he's apparently got 4 women willing to come forward and say that they've been abused by him. So we'll see. Very serious stuff. Very serious case, and it's at its early kind of inception here. But great question from Rachel from York, England. Thank you for calling in. Appreciate it. All right, let's move it along here.
Hi, Courtroom Confidential crew. This is Morin from the spectacularly beautiful Monterey Peninsula. Thank you so much for making Sunday Funday a weekly event. I really do believe it's the best thing going in the true crime space. Josh, I have a question. In watching the Linda Stermer trial, there have been many times that cross and recross have gone on so long that I have found myself almost overcome with nostalgic feelings about my last root canal, and I almost tear up as I long to be back in the dentist chair. It's as if both the prosecution and defense are in a contest to see who gets the last word, and that the contest is allowed to go on to sudden death. And I'm talking about the death of the first one who drops dead from exhaustion for the effort. So I realized I've been living in the fool's paradise of believing that there's a limit to the number of times you can recross, and that because the prosecution has the burden of proof, they get the last word. So what is the rule? I realize there's probably different rules for different jurisdictions, but what is the rule? How long can they go on? Thank you for the answer to this question.
Oh, Maureen. Oh, I love you, Maureen. That was fantastic. Maureen from the beautiful Monterey Peninsula here in California. Thank you for calling in. God, that was funny. Look, Maureen's question is, she's been watching the Linda Stermer case, and it sounds like she's been watching it with a IV drip of painkillers to just get through it. But she asked the question, and the attorneys in this case keep on going back and forth. Well, they'll have direct, cross, redirect, recross, redirect, recross, redirect. The answer to your question, and I've heard some people be critical of this judge too, that this judge may not have a control of this courtroom like you would hope for. And I'm not trying to throw this judge, pardon me, under the bus, but the answer to your question is it's up to the judge. It's not just each jurisdiction and it's up to each judge. And I don't even think there's really a rule on all of this. But in some courts, and I've had the pleasure and honor of being able to practice in several different, counties in this state and in other states. And it's always so funny to me how, I don't know how to describe it. It's like you know generally what to do and where to go, but you also feel like it's your first time doing it. And it's like, I don't know how I would explain it. It's like you've been riding a bike your whole life, and all of a sudden you're now on one of those old timey bikes. It's like you kind of get it, but you don't get it. It's a horrible metaphor. I'll try to think of something better. But you walk into a court and you're trying to get the idea of how does this courtroom, even in the same state, handle their cases. And that even comes down to each judge might just have a different rule on this cross, recross, redirect. The answer, though, is you are generally not allowed to get into. So if you have direct and cross, redirect should only be about new things that were brought up on cross. So I have to clear up something that was brought up on cross. And then recross should only be to confront whatever brand new issues were brought up on redirect. In other words, this isn't the opportunity for just everybody to have the last word and continue to talk about the same questions and same topics again and again and again ad nauseum for poor Morin. This is about if there are new issues brought up. I've had judges who you do cross, you do direct, cross, and that's that. Maybe redirect and maybe recross if there's anything out of that. But the judge will just be, we're done. We're moving on. And I kind of appreciate some of those judges. Sometimes I get a little frustrated because it's like, well, I want to make one little nuanced point here, and the judge feels like that point's been made. Other judges, like this judge, just kind of let things go until they both run out of words to say. But you're dealing with attorneys, and they never run out of words to say. Here's exhibit number 1. So great question, Maureen. Sorry that you're torturing yourself with that case. But if you want to be upset and write a strongly worded letter to anybody, it's probably to the judge. All right, let's move it along here.
Hi, Josh. This is Christine from Langley, BC. This week I was over at Defense Diaries watching their coverage of the Lori Vallow Variety Hour. It was wild, to say the least. There were times that I couldn't keep my eyes open, and then there were other times that it was really juicy. But my question is about her advisory council. I think we can all agree that Lori is possibly one of the biggest turds to ever walk the earth. But it appears, at least it appears, that she isn't receiving a lot of help from her advisory council. It was getting to the point that even I was yelling objection, and I know nothing about being a lawyer. Maybe the person next to her is actually kicking her under the table to object, and she's ignoring any advice. That wouldn't really be all that shocking. Do you have any information, though, about what the role of her advisory council is? I was just wondering if he or she is required to prompt her when to object, or is it completely up to Lori to ask for help? So anyway, thanks for taking my question, and have a good week.
Christine, thank you so much. Calling from Langley, British Columbia, Canada. Throw it up on the map. Thank you. Appreciate you calling in. And great question, too. First of all, shout out to Defense Diaries. Bob and Allie over there doing incredible work, and they are friends of this show, and we are friends of theirs. So thank you for bringing them up. But your question is about what is the role of advisory council to Lori Vallow? And it sounds like, well, it doesn't sound like you are telling us you're frustrated with the fact that it doesn't seem like this advisory council is doing anything to tell her when to jump in or when to object. And I imagine your question is not coming from a place of wanting to help Lori as much as just what is that person doing there? The answer is this. And again, this is another thing that's kind of up to the judge to decide how much to allow or not to allow. The answer is this advisory council is basically supposed to do nothing but sit there and answer questions about things that Lori might not understand. Things like objection, hearsay, Your Honor, it's not being offered for the truth of the matter asserted. Lori can then turn to her advisory counsel and say, what the heck does that mean? And they will explain to them hearsay and how it works and why not being offered for the truth might be something important. This person's supposed to act as a translator more than anything, to help her to understand when the judge says, we're going to have to talk about that in camera. She understands what in camera means, and the advisory counsel can explain to her, well, that means the judge wants to talk to you in private back in chambers with nobody else around. Things like that. But they're not supposed to be the lawyer, and they're not supposed to be coaching, and they're not supposed to be saying objection. That's not their role. She's the lawyer. She did a bunch of waivers. She made a bunch of arguments. She said, I have waived my right to counsel. I want to represent myself. So that advisory counsel should not be stepping in. Now, is the advisory counsel giving her hints and telling her and kind of coaching? Perhaps. And it's up to the judge of how much of that to allow. I can't think of a reason why that would be entirely inappropriate. But I imagine if it became too much, the prosecutor could even jump in and say, what are we doing here? Who's the attorney? Who's announced their appearance? I believe it was Lori Vallow representing Lori Vallow. What do we got this other person doing here, interjecting? And certainly if that person tried to speak up on the record. But great question, Christine. The whole thing has been, what did you call it? The Lori Vallow variety hour. It really has become a interesting, flaming dumpster on wheels type of a case to watch, and I am here for it, and that will continue next week. Thank you so much, Corrine from Langley, BC. All right, what do we got next? Oh, pardon me, Christine. I said Corrine. Christine from Langley. All right, let's keep it rolling. I got to get my technology all in shape here. Oops. Here we go.
Hello, community. This is CJ in LA from Los Angeles. I hope you're all doing well and enjoying your Sunday. Hopefully, I'm tuned in live, but I spend most of my weekends as a parent Sherpa or unpaid Uber to my small kids or at a various game or birthday party, so who knows? So, Josh, I initially wanted to ask you about your thoughts and reflections on restorative justice versus retributive justice in the United States. But since I imagine this weekend will be Lori Vallow heavy, I thought I'd ask the following. In another world where you are not in law, what would you be doing professionally? Thanks so much, all, and happy Sunday Fun Day.
CJ, calling from Los Angeles. Put it on the map. CJ, I always love your questions. They're always so well prepared and well thought out, and I appreciate that. What a great question. What would I be doing professionally? Well, I'm trying to do it, CJ. I'm trying to become a professional YouTuber. So help me out here. Spread the word. As soon as this thing catches fire, I am walking away from the practice of law. But this is funny. And I've told Tiffany, my wife, by the way, she says, you have to tell people I'm your wife. Tiffany, my wife, I tell her this all the time. I think in another life, I would have been a chef, a professional chef. I really enjoy cooking. I'm going to say celebrity chef for Josh. That's funny. I really do enjoy cooking. I don't get to do it all that often, but I've got all the books and I'm fans of the big chefs. And I think I've completely romanticized the profession in my head. I imagine it is far more brutal and involving being back in sweaty, awful kitchens all night long and coming home with your back aching and you know, all of that stuff. But in my head, it's this, you know, beautiful creation of wonderful flavors and foods, and you're just kind of going out and visiting the tables and, you know, in between TV appearances or something like that. But I think I would love I think I would love would have loved to have gone to culinary school and perhaps pursued that. But, you know, culinary school, law school, it was kind of a toss-up. New cooking channel. Yeah, maybe that's what the announcement is. Stay tuned, JC Broadway. Maybe that's the big announcement. Allie B from Tennessee says, Tiffany is lucky if you love to cook. I do love to cook, and she does like my cooking. I just don't get to do it all that often because anymore we're making dino chicken nuggets and mac and cheese for 3 little ones just to try to get them to put some food in their belly. But thank you so much, CJ from LA, for calling in. All right, let's keep it moving here.
Happy Friday afternoon. This is the Shenandoah Valley of Virginia, touching base again. This is Annie. I wrote in the text, but I also will just put a quick voicemail. Why are we calling 18-year-olds children? We as the mentors and teachers and parents in their lives should be really encouraging them to do self-care and self-love so that they're making wise decisions. I'm not saying don't drink. I'm saying don't be drunk. I think Ethan especially would have been able to fight off any intruder in that house, especially Mr. K. We lost 3 young men 2 years ago here that had a fraternity function in which they were made to drink, and then they went to a not a good place and then came back and did whippets and they were killed. And then Riley Strains. So I think we need to re-examine as the adults what we are teaching them by calling them children. They are not children. And we need to set the example. Thank you.
Annie calling in from the Shenandoah Valley in Virginia. Thank you so much for this phone call. Look at that map. We are really starting to fill it up. I love it. Great. Not even so much a question as much as a comment, Annie, but a very important comment. And I appreciate you saying that. And Annie is saying, and I don't want to put words, but I'm trying to interpret in my own way of thinking about it, saying, what are we doing calling them kids, as if that somehow excuses some of this behavior. And you're right. These are young adults who are doing very adult things, but doing them in a very immature manner. And especially when it comes to drinking, when you see this kind of overindulgence that leads to tragedy, like we did with Riley Strain. And what a tragic case that was, where this young man lost his life in a way that was easily preventable had both he been more adult, and I'm in no way trying to blame this young man, but had he been more careful with his drinking, had his friends been more careful with their drinking, had they been watching out for him, we would not be talking about the tragedy of this young man. Same with the Idaho 4, and I don't know if you can blame it on drinking, but part of the reason we don't know exactly what took place in that home, or why people didn't wake up, or why they weren't alerted, may have been because of the drinking. And again, placing no blame on any victims here, but it does seem like alcohol continues to play a role in many of these tragedies. College life, unfortunately, involves a lot of partying, says Jody Arrington. That is very, very true. And I'll add to this conversation by saying, in my practice as an attorney, not so much anymore, but I used to do a lot of what are called Title IX cases, which are cases of allegations of sexual misconduct between students. And they don't usually rise to the level of something criminal, but they rise to the level of where the school is now contemplating whether or not to punish someone, which could include expulsion. So now you have these young folks who, and in every single one of these situations, everybody is drunk to the gills. And they go to these fraternity parties and they get out of their mind wasted, and they end up hooking up or doing something, and the next day everybody's got regrets and everybody is feeling like there's a lack of consent and all of this other stuff. And I'm not trying to get into the politics of Title IX and everything else, but what I am trying to say is that every single one of these cases, now you're talking about some young person who is going to have their entire college career ripped from them, They may not be going to prison, but their future may be hugely impacted. And alcohol played a major role in all of that. So I'm not trying to be a teetotaler here. I'm not trying to chastise, but boy, is it a problem that we still continue to kind of turn a blind eye to, because we call it, oh, isn't that just being in college? Stefania says BK has no alibi, meaning it doesn't consider an alibi in court of law. The defense said they only have a partial corroboration. Does that mean he has to testify? If not, why? So this question, Stefania, has to do with the prosecution saying they haven't presented evidence of an alibi. And in Idaho, there's a requirement that they actually present evidence to support an alibi if they're going to make that argument. And the prosecution is saying you have not provided any of that evidence. So therefore, if you want to testify to where he was at that time, that's going to have to come from his own mouth. That is something still being litigated by the court. The court, I think, has found that this new expert, Cy Ray, may act as some sort of partial corroboration of the alibi. But I think the prosecution actually makes a pretty good point. Unless you're going to prove to us that he wasn't there at the time of the murders, and that's what you want to argue, well, then you got to present us with some evidence, and we don't have any, and therefore the only person that could testify to that would be your client. I say buckle up on this one. I think he might testify. I really do. I'm not trying to be outrageous here, but I think that this is one of those cases where he might actually take the stand, but we shall see. All right. Great question, though, Annie from the Shenandoah Valley. Appreciate you. Let's move it along here. Hold on. Here we go.
Hello. Hi,
Yeah? Okay.
Courtroom Confidential. Hi, everybody. So, Josh, my question is, Karen Reed 2.0 starts Tuesday. You're Alan Jackson. How are you feeling? Do you have your opening already written? I know that he will be doing the opening statement. I know you also know him personally. So how is he feeling? Is the opening statement already written? How do you prepare? What if you were Alan Jackson? What will you be doing? How do you prepare for such an enormous opening statement? Thank you. Can't wait to hear your response.
Thank you so much, Sonia. And I know you're from Chicago because you've called him before, and I spent some time in Chicago. So hello there. Next time you call in, Sonia, I want to know where in Chicago too, because I lived in the northwest suburbs for a little while. Great question. This is talking about Karen Reed, and more specifically, Alan J. Jackson, and how is he feeling? If I know Alan Jackson, and I do, he's feeling pretty good. There's not many days that Alan AJ does not wake up feeling pretty good and pretty confident. That is one of the qualities that he has. I'll tell you briefly how I know him. I kind of referred to this or alluded to this earlier, but he was when I first was hired as a law clerk in the DA's office. He was in major crimes, and I was a law clerk in major crimes, and I worked for him. I worked on the I was his law clerk during the Phil Spector trial, not the first one, but the second one where we got the conviction. And so I've known him for, we're going on 20 something years now. And he's been a very close and good friend and mentor for a very long time. And I was a DA in the same office as him for 10 years. Then when he left the office, I left the office, and I was his law partner as a criminal defense attorney for a very long time too. And I recently left and kind of struck out on my own, but we still maintain a friendship, and he's a great guy. And now he's wrapped up in the Karen Reed circus. And I did not know that case. I think that case was coming into his office as I was leaving it. So I have not been a part of that whole mess, so I feel free to talk about it. But he is, you asked, is his opening statement already written? Not is it already written. I imagine it's been written for weeks, if not months. If I know anything about Alan, he's an incredibly hard worker and he's incredibly well prepared. And as much as what's taking place in court looks extemporaneous and him kind of shooting from the hip, a lot of it is, but a lot of that is prepared. A lot of that is in his notes, and a lot of that is in his head, waiting for certain moments to pounce and say certain kind of prepared comments to catch people off guard. But he is one of the brightest attorneys I've ever worked with, and that's because of his courtroom skills and his ability to pivot and think quickly. But he's also incredibly well prepared. You don't get that good by walking in and just kind of shooting from the hip and picking up the file for the first time that morning. You get that good because you've become well prepared. So I think he's ready. I think he realizes this is a moment. He's built for these things. He looks forward to these things, and I think he expects to rise to the occasion. And I will be watching it. And in fact, I hope you all will be watching it with us. Like I said, stay tuned for the very end of this show. And we got some announcements coming up for you, but we have a place that we hope you will join us to watch this trial. And I think it's going to be a very entertaining one. I know it's kind of like the second go around, and we're expecting much of what we saw the first time around. But I think I don't think it's going to be the same as the first time around. I think we're going to hear a lot of the same stuff. But I think this case will develop in a much more different and dynamic way. So buckle up, everybody. If you are a fan of really good trial advocacy, you could not do much better than what's going to be coming up in that case. So thank you for that question, Sonia from Chicago. All right, let's keep it rolling here.
Hi, my name is Kim Lindgren, and I'm from Bowling Green, Kentucky. My question is about the Dan Markell murder case. Charlie Adelson willingly and knowingly hired an attorney in Daniel Rashbaum who had represented his parents before. How can Charlie now claim a conflict when he willingly entered what was obviously a conflicted situation? Thank you.
Kim, putting Bowling Green, Kentucky on the map. Let's see it. Thank you so much, Kim, for calling in. There's Bowling Green, Kentucky. Look at that map. I'm loving it. Kaylin, once again, round of applause for Kaylin for putting this together. I said to Kaylin, I'm like, wouldn't it be cool if we had a map just about that specific? And then, you blink and turn around, and she came up with this whole thing. So thank you again, Kaylin. All right, Kim from Bowling Green, Kentucky. I can tell by the inflection in your voice that you are a little off-put by the shenanigans in the Adelson drama. Dan Markell, this wonderful man, was murdered by a basically crime family at this point. Charlie Adelson has been tried and convicted and found responsible for orchestrating his death and being directly involved in hiring the hitmen. And now Donna Adelson will soon go on trial, Donna being Charlie's mother. There she is, looking very concerned about her prospects. And she's going to trial here very soon. And the issue is they both hired this man, Dan Rashbaum, the same exact attorney. How did that happen? Was that appropriate? Where does that leave us now? So Dan Rashbaum had represented Charlie when Charlie was first indicted and arrested and tried, and he handled his entire case. But before all of that, Dan had actually been hired by the quote unquote family when this whole investigation was taking place, and they saw that other people were being arrested and convicted for this crime. They said, maybe we better lawyer up, and they got Dan. And Dan, at one point, my understanding, was representing basically everybody. Charlie and Donna, in kind of the anticipation of representing the family and not knowing exactly where or if the government was ever going to indict anyone. That is not a problem. At that point, it's not a problem. It's not a problem to represent more than one person when they all kind of have their interests aligned, okay? Where the problem arose was when Charlie, got indicted and put on trial. And now he's convicted. Now he has represented someone in court, okay? when then Donna, within days of that, is arrested and indicted, Rashbaum decides he's going to go ahead and represent Donna as well. At that point, he should have withdrawn. I really do think that. Is it illegal that he tried to represent her? No, but it's just asking for trouble, and we saw the trouble arise. Now, apparently he had a conflict waiver, meaning you can represent more than one person in the same case if you get a conflict waiver, meaning they're waiving conflicts regarding representation of people who might have opposing defenses. In other words, even though they're all saying we didn't do this, you could easily see a situation where they might start to point the fingers at each other. I don't care if it's mother and son or anybody else. Fingers are going to start to get pointed when you're looking at prison for the rest of your life. So he said he had a conflict waiver. Turns out that conflict waiver was only orally given. Then Charlie ends up on the prosecution witness list in Donna's trial, likely as a rebuttal witness if Donna actually testifies. Charlie gets transported to Tallahassee in anticipation of that trial and then says, by the way, I don't mind testifying, but I'm not going to be cross-examined by my previous attorney. And not only this previous attorney, but anybody who works with him. Obvious issue, everybody. And the judge says, yeah, that sounds like it might be a problem. And that's when Dan says, well, I thought I had a waiver. Apparently I don't have a waiver. No, I've got this other attorney. We've walled him off. We can consult with conflict attorney and see, you know, blah, 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 blah. Judge says, you know what? This whole thing is such a mess. I'm done with all of it. Dan, you're off. Other counsel, you're off. Everybody's off. You got to get brand new attorneys in here, and we're going to start fresh. And I applaud the judge for doing that, because there was no reason to muck this whole thing up from the very beginning. Start fresh like we should have, and get a brand new team in here. So a really interesting case. To answer your question, though, Kim from Bowling Green, it really was not a problem at the start, but became a problem, and wiser course of action would have just been to get off the case. But you know what? I don't know if it was paychecks or if it was cameras that may have inspired him to try to stay on this whole thing. And I, again, you know, not trying to throw people under the bus, but that was a bizarre decision. But thank you so much, Kim from Bowling Green.
Hi, it's Kim Lindgren from Bowling Green again. I actually have a second question, and this has to do with the Karen Reed case. In the first case where in the first trial where a mistrial was declared, could the jury have been polled? And if so, could that have prevented the issues that they faced before her retrial, with the fact that there was a conflict as to whether or not the jury had actually reached a verdict on a couple of the charges? I don't understand why polling the jury isn't automatic or more common. Again, thank you for taking the time to answer my question.
Absolutely, Kim. You asked some great questions here. Again, this is Kim from Bowling Green. Karen Reed. Okay. Many people are saying, why in the world why didn't the judge just poll the jury? That seems like it may have solved a bunch of problems with this case. It may have. Had she polled the jury, then we would have found out about the whole acquittal issue, if that were in fact true, and we would be in a very different place today. We might not even be in a trial. She might have accepted some sort of plea to something else, and we'd be on our way. But we're not. And the jury was not polled. And the question is, shouldn't that be automatic? And was that a mistake for Cannoni? I understand all of the grief that Cannoni gets, and I understand all of the shade that she enjoys. And I think some of that's deserved and some of it not so much. And I actually, Kaylin, if I'm going to try to present this document here, I think some of it, hold on. Oh, I'm going to mess everything up. Kaylin, hold on. I know I'm going to mess it all up, but we're going to do it anyways. I wanted to read this to you because this is this is one place where I'm like, I don't think the judge deserves all the criticism she's getting on this. These are the questions that were presented in court from the jurors. And this is the opinion that came out from the appellate court on this, and they included all the questions. The first note said, or not questions, notes from the jurors regarding whether or not they were hung. First note says, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. First of all, starting off, one of the most clear-cut notes from a jury I've ever seen in my entire life. Like, usually the notes that come back from the jury are like, what do we do if we don't think we can agree? Or if it looks like we're having problems agreeing, what box do we click? Like, they're just never as clear-cut as this whole thing. The next note then comes out. The judge sends him back in, says you haven't worked long enough, continue to work at it. Note number 2, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Incredible, this note. Like, look at how clear-cut this note is. We are hung, Your Honor. We're trying. We've done our best, but these are deeply held convictions, and we're never going to get anywhere. It does look like an attorney wrote this, or somebody who should be an attorney. Thank you for that, Simi. Then, finally, judge says, no, I give you the dynamite instruction. I'm sending you back there again. Get me a verdict, folks. By the way, all through this, defense asking for a mistrial, prosecution saying, let's keep going. This is note number 3. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. And you can almost hear the eagle cry and the Star-Spangled Banner and the fireworks go off. Like, I've never seen a note like this in my entire life and practice. This is as clear-cut you can get that we are hung. And now people are saying, well, shouldn't she have pulled him? Maybe she should have. But I'm telling you, if we receive this note, I will be willing to admit, if I were on defense or prosecution and we had received this note, I am saying to the judge, okay, we've got a mistrial, because it could not be as more clear-cut. And polling is not automatic. And in many times, the judges don't like to interfere with what the jurors are doing. They don't want to know. I have had judges pull them out and go, okay, listen, I don't want you to tell me if you're leaning towards guilty or not guilty. I don't want to know your votes. I just want to know, what is the vote? Is it 10-2? Is it 6-6? Basically to get an idea of how evenly split they are, if the idea of sending them back will do anything more. But here, the judge didn't do any of that and just declared a mistrial. And now we're seeing Karen Reed 2.0. And so the answer to your question, Kim from Bowling Green, is it's not automatic. It's not even all that common. It would have avoided a mess in this case, but we didn't get there. And, it is what it is, kind of a deal. It's the frustration I can completely understand, but it is kind of what it is at this point. But thank you again, Kim. All right. Did I mess this all up, Kaylin? Kaylin's giving me a look like, yeah, you messed it all up. Let's see if I can do this properly here. Okay. Let's keep it moving.
Hi, Josh. I was watching the hearings with Bryan Kohberger.
Oh, sorry. I messed this up.
Hi, Josh. This is June, and I ran out of time on my first message, so I'll try to be a little bit quicker on this. I'm curious about the interlocutorial um, appeals that could take forever in lines of the Kouri Richins case that the judge was talking about, and also about the change of venue where he denied that and stated that if they if they do not uphold the denial of the change of venue, saying that that was incorrect, that he can go and get a jury from a different county, but not move Kouri Richards and attorneys and everybody to like the Salt Lake City area or counties. I just wondering if you can go more into the interlocutorial and the jury pool, along with the statistics that he used in order to deny the request for change of venue. Again, this is a Kouri Richardson's case and not the Bryan Kohberger's case. So if you could please forget the very, very first one where I mixed up the trial and the last two that I just recorded, are the question that I had in lines of the change of venue for Kouri Richards. Thank you very much, and you have a good day.
Thank you so much, June. June had called in and then corrected the question, and so I didn't play all of June's questions, but thank you so much, June. And June, just let us know where you're from. That was the only part I missed, but excellent question about the Kouri Richins case. And so recently there was a bunch of discussion in this case about a change of venue. I got a real bone to pick with these change of venue things, and it seems like they're the en vogue sort of motion nowadays, where you get a case and it gets a lot of attention, and then all of a sudden they say, well, we can't try this here. Everybody knows about it here. We need to try it somewhere else. First of all, the television wasn't invented yesterday. Newspapers have been around for a little while, I understand. People have been following cases. I mean, Lizzie Borden that we talked about was talked about everywhere in the world at that time. And the idea that all of a sudden we're in this influx of media attention that just cannot be outdone and we're never going to find a fair jury, I kind of have a tough time buying. And I will tell you from experience, I've been a part of cases that are headline making cases. And you bring people in and they don't know, Phil Spector is a great example. We brought in a bunch of jurors and there were people who were like, I never heard of this guy in my entire life. I don't know what this is about. I don't know who this is. I know about the LA Dodgers and I know about my kids' PTA meeting, but I have no idea who this is. And I imagine you will find people about Kouri Richins. But, I don't fault the defense attorneys. I understand you want to get a fair trial and you don't want to go in with people who just have a tremendous bias in that case. And when the smaller the community and the bigger the case, I can understand where those concerns arise. So here, June asks about, first, there was a study done. Here's the results of that study. They tried to figure out how big of an impact this has on this community. Summit County, where this is taking place, has 42,000 residents. They did a poll, not of everybody, obviously, but they did a telephone poll. They found that 80% of people polled recognize the case, 60% think she's guilty, and 50% say that they're unable to be fair. Pretty high numbers. Salt Lake County has 1.2 million residents. There, 43% recognize the case, so nearly half. 58% think she's guilty, and 41% say they're unable to be fair. The judge looked at this and said these are negligible differences. Now, you could look at that and say, no, they're not. The judge looked at it and said they're negligible. There are differences that I think the judge is saying we could probably get past. We could probably still find jurors that fall into those group of people who may recognize the case but haven't made up their mind. He also pointed out that this case does not involve the same type of what he calls inflammatory factors seen in other cases where the case has been changed. Meaning, does it raise political type issues or issues that are so inflammatory to some people that we need to move it out of this community? Was it involving like the mayor of that community or something like that? Not here. And then he points out, and this isn't a small consideration, but logistical issues, because how are we going to transport everybody involved in this case to a different county? How are we going to transport jurors from that county to here? What are we going to do? It's going to create a big mess. And the judge said, no, not going to do it. Not going to move not going to move the trial. One other thing on this, the standard is reasonable likelihood that a fair trial could not be had. And the judge felt it just did not rise to that standard. And that the media coverage was not so substantial that it was prejudicial. Okay. So then they filed, and this was part of June's question, an interlocutory appeal. And what is that, and what does that do? An interlocutory appeal is basically an appeal of a decision made either before or during trial. In other words, an appeal not of the final disposition of the case. So the case has not had a verdict. You're not appealing the issues contained in that. You're appealing issues as they take place while it's still going on. Oftentimes this is called a writ. I'm going to take a writ on this issue and I want to have this heard. And the reason you get to do that is that you feel that it is so important because it will significantly affect the outcome of the trial. So in other words, judge is not going to allow certain testimony, and you as the defense feel that testimony, either being allowed or not being allowed, will have such an impact on the case that you cannot wait to take your chances to see if there's a guilty or not guilty. You need that decided now. These issues are incredibly rare, and incredibly rare for the Court of Appeal to even hear them, because most times the Court of Appeal goes, well, let's see. We don't know if it's that you say it's going to be a big impact. We don't know. We don't know. We don't want to get involved in this thing without there being a decision on it. So you're saying bad, prosecution saying not so bad. We're saying we don't know. So let's see how this whole thing plays out. So the idea of these things getting granted is very, very rare. But the judge said, fine, you want to take this interlocutory appeal? I'm going to put everything on hold until that's all sussed out. And I think that was a wise course on the judge's part. The downside from that is now we have to wait for this trial to actually kick off. And what could happen is they could send it back down and say the judge didn't make a mistake, start your trial, or they could send it back down and say the judge didn't make a mistake, you need to move that trial. And I think that probably will delay it even more. So great question, June, wherever you are from. Thank you so much for calling in. All right, let's keep it moving here.
Hi, Josh. This is Sloth Life, or Angela is my birth name. I'm calling from Paisley, Scotland. I'm just following up on my chat message last week. I would love to hear your thoughts on the Scottish court system having the 3 verdicts, in particular the not proven verdict. I would love your thoughts on the fact that the judge doesn't give instructions to the jury on any definition of not proven. There is no legal definition that has been determined. So just calling in to say that I absolutely love the show. I unfortunately don't always get to catch a live because of the time difference between Scotland and the US, or in particular, the region that you are in. But I would love to hear your thoughts. Love the show, love hearing your views on everything. And I found you through Recovery Addict. And I'm really looking forward to Sunday Funday, because I will be able to join you live. Sorry, I'm tripping over my own words here. I'm a bit nervous. Anyway, I'm looking forward to tomorrow, Sunday Funday. Take care. Have a great stream. Thank you very much. Bye.
Oh, Sloth Life, Angela, thank you so much. I think you sounded wonderful, and I appreciate you calling in, and I loved hearing the sound of your voice. And you call in from Paisley, Scotland, so let's put it on the map. And it's a great question, too. Angela Sloth Life had actually asked this, I think, in a chat or something, and I remember this question, and we were not able to answer it, and I'm glad that you re-asked it, because it's a really interesting concept that takes place in Scottish law. So I had to do a little research into Scottish law. So here in the States, we have two verdicts, guilty or not guilty. The only way it would end before a guilty or not guilty is you have a mistrial, which is not considered a trial at all, and you do everything over again. So guilty or not guilty, those are the choices. In Scotland, they actually have a third verdict, which is not proven. What the heck does that mean? Well, it's interesting because it's almost like a sassy not guilty is the way I would put it. It's a not guilty with a wink. It's basically saying the jury is not convinced of the defendant's guilt beyond a reasonable doubt. In other words, the prosecution didn't give us enough evidence, but we're also not entirely convinced of your innocence. So we don't want to put a stamp of not guilty on this because we're still raising our eyebrows, but we are not going to convict you of the crime. So it's not a complete exoneration in the sense that you still receive kind of the reputational harm from it. And I thought that's so interesting and so kind of cheeky on the part of the Scots for doing that, because right, it's a sassy not guilty, because it really doesn't have a legal effect. We say here all the time, we talk about not guilty doesn't mean innocent, and that's true. Not guilty means you haven't proven it. But we walk away from not guilty saying, I'm not guilty, I've been acquitted. And the PR spin is therefore innocent, but not guilty is very different from innocent. It's not, the choices here in the States are not guilty or innocent, they're guilty or not guilty, and not guilty means something different than innocent. But the Scots say, well, we want to make sure that point is clear. So we're going to have not proven. But it's still, double jeopardy still attaches. All of the other issues that, all of the other consequences and benefits of a not guilty are still attendant to a not proven, including that you can't be tried again. You've been acquitted of that crime. But then, Angela, Sloth Life, this got me thinking, because I'm wondering what are the rules on double jeopardy in Scotland. And so I went on another little tangent. And Scotland's got some really interesting rules on double jeopardy. Here in the US, if you have been acquitted of a crime, you are done forever. You are untouchable. You could do a press tour about how much you enjoyed killing the people you killed, and there's nothing to do about it because you've been found not guilty. In Scotland, not so much, according to the Double Jeopardy Act of 2011. And let me just give this little asterisk disclaimer. I am not a Scottish expert on law. This is just off of the research I've done. But if new evidence comes forward, or if it was shown that there was perjury or fabricated evidence admitted at trial, or if you make subsequent admissions of guilt, they will turn around and try you again for that case. So, lesson learned here to Sloth Life or anybody else in Scotland: once you've been acquitted of that murder, just keep your mouth shut, because you never know, they could come back around. Very, very interesting stuff about how things are handled around the world, and I appreciate you calling in with that question again. Oh, no contest, please. When a person can plead no contest, like not admitting to being guilty but accepting the sentencing. Yeah, no contests are interesting too. No contests have zero legal effect criminally, and each jurisdiction kind of handles them differently. Here in Los Angeles, they take no contest pleas all the time. They're also called nolo pleas, nolo contendere. Basically, it's a way for the defendant to say, I don't want the word guilty coming out of my mouth, but I do, for other reasons, accept responsibility for this because the consequences could be worse, or I'm accepting a plea, or what have you. It really does not have in fact, they're told it has zero legal effect on how this case will be handled and whether or not you're sent to prison. The only effect it could have is perhaps in a civil context of if you're ever under deposition and asked, have you ever pled guilty? You can say, no, I've never pled guilty to anything. I pled no contest. But it's just, again, kind of one of these little gray, I guess you could call a no contest plea a sassy guilty plea. All right. Thank you again to Sloth Life for calling in. Let's keep it moving here.
Hi, Josh, and everyone at Courtroom Confidential. It's Damaris from England. My first question is regarding for instance, Judge Canoni in the Karen Reid trial that's going to be starting again. When listening to testimony, every time Mr. Lally it was, and it will be Mr. Brennan, obviously, objects and objects and objects, instead of saying overruled, she will say, I'll allow it, I'll let him have it. Or she will ask a roundabout question to the witness, like, can you answer that? Do you know that? And I'm not saying that never happens in any other trial with any other judge, but it just seems to me that it's very, very dominant in the way that she responds, which, in my opinion, seems to present to the jury that she's doing the defense a favor by allowing them to ask a question that actually they probably should have been allowed to ask anyway. And I just think that puts them in a bad light. And anyway, I wondered, is there any way that the defense could actually have a conversation with the judge in open court or anything to say, could we please request that you say overruled instead of I'll allow it, etc., or not ask, allow us to ask the questions to the witness. Sorry, part two. So how much leeway is there between the lawyers and the judge to be able to perhaps request that certain things are done a certain way, which is not out of the bounds of how other judges do it? Or is it, this is my courtroom, I'm the judge, this is how I do it. It doesn't matter how it looks to the jury potentially, or how it makes you feel, or how it possibly belittles the lawyer, etc. Or is there any conversation that you can have like that? My other question was, obviously the jury is such an important aspect of the whole judicial process, because they are the ones, the finders of fact, that can change somebody's life for better or for worse, or bring somebody justice. Why is there not some kind of jury class or a video, 30-minute video, that can speak to the jury and say, this is what your job is, this is what the rules are, these are how you approach it, these are the questions to ask, this is what to listen for, etc. Because so much conversation I hear after trials or during trials or listening to lawyers on YouTube is how unpredictable a jury is, but how often it's that they didn't know what they were doing, they didn't know this was the right way, they weren't listening for this. So for something so important that could save lives, change lives, save money, why was something like that? I am really sorry for this part three and final message, and I don't expect you to play them all or any. What I'm saying is, why is that not something that's thought of as being something vitally important? That if the jury really had some kind of training, even if it's minimal, in what a juror is supposed to look for, what this means, what that means, then we could save so much heartache, problems, money, court time. My last question is, when somebody is already in prison, like Laurie Vallow, for instance, she's already in prison forever. Why is it that they spend so much money on trying a case, like, for instance, now with the conspiracy to murder her husband, Charles Vallow? I understand that perhaps for family, they feel this is awful. We know she did it. It should be publicly known that she did it. But if someone's never getting out and everybody knows that it's likely that the person did it, isn't it a waste of court resources and valuable time and money to go through this process, which at the end of the day, if she's found guilty, nothing's really going to change. Or is it some sort of legal process that has to be done? Or is it for the family's sake? Is it for things to do with, I don't know, paperwork? Anyway, loads of love.
Thank you so much, Damaris from England. I love that. We love hearing you, love hearing your voice. Great question. First of all, put her on the map. There we go. Okay, let me break down these questions here. First of all, Karen Reed, talking about Judge Cannoni and her response to objections are things like, I'll allow it, I'll let him have it. Can you answer that? First answer to this is that's particular to each judge. Every single judge kind of handles it differently. Some judges keep it to sustained or overruled and move on. Other judges kind of give their little commentary like Cannoni. Other judges are even more involved. I've had judges that not only just, will turn to the witness and say, can you answer that? They'll say, well, let me ask you this, and start to ask their own questions, which I nearly want to throw my stapler at them when they do it, because it's one thing if the jury wants to ask a question, we can all talk about it. It's another thing when you've got a judge going completely off the rails, asking questions in the middle of your trial. But the answer to this is, can they ask the judge to please only answer objections with either sustained or overruled? Sure. Do you want to do that with this judge? Probably not. Probably just deal with it. They're already kind of on thin ice with this judge as it were. And I can understand the frustration, and I can understand your frustration, Damaris, and I can understand how it might be interpreted that she is leaning towards one side or the other. I guess the reason why this doesn't bother me as much is I have lived this my entire professional career, that judges are, it's just like people. You're going to have people you like, you don't like, smart ones, good ones, bad ones, and everything in between. And you just get used to, there are some judges that are just going to make your life miserable, and everything about how they handle it is going to make it miserable. And you got to keep your head down and keep your eyes on the prize and keep battling on. And I've just lived this for so long that Cannoni, honestly, when you've seen the judges I've seen, Cannoni's a walk in the park. She's got her little, I don't know, picadillos or whatever you want to call them, that make her interesting and frustrating. But believe me, Alan's seen far worse too. And I know he's frustrated, and I know that it probably drives him nuts when he's not inside the courtroom, but he's dealt with far worse too. So the answer is, just let the judge, and what she's doing by saying, I'll not allow it, I'll let him have it, things like that are not all that galling to me. The next question Damaris asks is about jury classes. Did we give them a class? Can we tell them what to do? The answer is we already kind of do. I mean, when you go in for jury selection, they do kind of tell you, hey, this is what your job and this is what you're here to do. All through voir dire and jury selection, you're telling them this is your job and this is what you're supposed to do. Here's the thing. If you ever want to know the crazies that you walk amongst in your everyday life, then go down and watch jury selection one day. Because I got to tell you, it is hard enough to get 12 people to agree on what they want for lunch, let alone to work together, 12 strangers, and get along and follow the law and listen to the rules. You remember group projects when you were in school and you had 2 or 3 people? Now you got 12 people that you got to get everybody all on board to listen to the rules, follow the rules, not bring in outside evidence, not bring in their own opinions, not bring in their own biases and it is damn near impossible. And so, Damaris, when you say things like, thank you so much, Angie, for becoming a member. Damaris, when you say things like, I hear attorneys say how it's a crapshoot. Well, it's not entirely a crapshoot, but it's about as close as you can get without it being inside of a casino, because it is amazing how often juries do things that they're not supposed to do, despite the judge telling them, despite you losing your breath trying to tell them. Shy Gal says, can the Commonwealth change their story of what happened to O'Keefe in the second trial? The answer is both of them can change their story if they want to change strategy. If they want to say, if the Commonwealth wants to say, well, he was hit one way and fell a different way or something like that. I think that's where you're going with this, Shy Gal. Yeah, they can. I mean, if they call the same expert from the first time to change his story, he's going to get ripped apart. But if they call a different expert who has a different theory on it, they can. So by the way, can the defense. The defense could change strategy completely. The only ways that it's going to come back to bite you is if you call the same witnesses who now change their stories. But if you want to change strategy, you absolutely can. Anyhow, to answer getting back to Dameris's question, I understand your frustration with jurors. Again, I've been living this my whole life. And it is frustrating and a little nerve-wracking. And that's why I tell clients all the time, listen, do you really want to do this? Go interact with 12 people at random and tell me if you really want to go to trial and take your chances. Finally, Damaris and thank you so much, Laura, for the gift. Asked about Lori Vallow, and I've heard this question many times before too. Why try her again? Isn't this a waste of time and resources? What are we doing? She's never getting out. Couple of thoughts on that. First of all, ever heard of Harvey Weinstein? Harvey Weinstein was tried and convicted for several counts of sexual assault in New York. And then they tried him for the same exact thing here in Los Angeles. And people asked the same question. What are we doing? Why are we wasting our time? Why did we transport him across the US? He's already locked up. Guess what happened in New York? It got overturned. It got overturned. And he's going back to trial in New York. But things do happen. So do you need a little insurance out there when you've got somebody you want to make sure they don't get out? Sure you do. And that's part of the reason why they're trying her in Arizona. We don't know if there is some weird issue in Idaho that could get that whole thing overturned. So you never know. But I think the larger answer to that question is this is a different state, and that state has to protect the citizens and get justice for the citizens of their own state. And they're saying, yes, it's been done there. Yes, she's probably never getting out, but we have a dead body here that needs accounting for. And can you make the argument that, okay, I understand that and justice and everything else, but what about the money and the cost? The money and the costs, I always tell people this when I was a prosecutor. I got paid to be in trial or I got paid to sit behind my desk. It's not a for-profit undertaking when you're working for the government. The government is getting your tax dollars no matter what, and they're going to be using them no matter what. So I would rather them use them in trial convicting someone than to be sitting around doing nothing. So it's not like it's going to cost you more tax dollars. It's going to cost you the same tax dollars whether or not they're trying Lori Vallow or not. So I say go for it. I say Charles Vallow deserves justice. I say, it's an important enough case. We're not talking about petty theft. We're talking about murder. And I think that he and his loved ones deserved a day in court to have Lori put away. But I agree with you. I'm done hearing about Lori. It will be nice when this is all over. But thank you again, Damaris, for all of the wonderful questions. All right, let's keep it rolling. Let's keep it rolling. Where is our plane taking off to next, Kaylin?
Good morning, Josh, Kaylin, and Tiffany. Joshua, every time I hear your name, Joshua Ritter, it reminds me of John Ritter. And I'm kind of showing my age here. Three's Company. John Ritter, he was so funny. Anyway, thank you for taking my call. So I don't know if I said this. I'm Kimmy Cloverberry. I'm from Maine. My question is about defense strategies. In situations where the defense creates sort of a controversy and points a finger at other individuals, and that happens to cause them financial burden, say like the Karen Reed trial and, the whole internal investigation that had to happen, which costs, tax dollars. And I can't even imagine. So in cases like that, when they're trying so hard to pin it on somebody else, if they create a controversy and prompting internal investigation or anything else, that might be financially, creating a hardship, are they ever accountable for having to pay that back? Didn't know if this was something anybody else is interested in hearing about, but thank you so much for taking my call. Bye.
Thank you so much, Kimmy, calling from Maine. Let's put it on the map. Look at this. Look at everywhere we've been. I love it. Kimmy, great question. She asked about she asked about defense strategy. I read into that, the Karen Reed case, but she asked about defense strategy. And when you have these cases where they're aggressively kind of going after a third party culprit and, the havoc that may wreak on that person's life who's being accused, does the defense ever have to be held responsible for that? And I hear this I've heard this question more than once. Like, what are the consequences for kind of things said in court? Can you just say any ridiculous thing you want and just not be responsible for it? Well, the answer to that is kind of, yeah. There is something called litigation privilege, and it is an immunity from defamation lawsuits, from any kind of libel or slander for things that are made during statements that are made during the course of litigation or trial. And you say to yourself, well, that's absolutely ridiculous. I understand that. The answer is the reason we do that is we want people to feel unfettered to make the arguments that they need to make, either representing their client or a defendant or representing the people of the state where they are the prosecutor. That if they need to do that, they can do that. Now, it's considered an absolute privilege, meaning it's a complete immunity, not a qualified privilege. In other words, it's not a privilege where you have to make those statements even in good faith. So it is a huge protection for arguments and things made in court. And that's why you will hear oftentimes kind of outlandish arguments made by attorneys. And you think, well, why aren't they getting sued for that? But what it does not cover are statements made unrelated to the case. In other words, if you want to throw someone under the bus in the middle of a trial that really doesn't have to do with the case, that's not going to be covered. Or if you make those statements outside of court. And so that's why the statements made during press conferences are far more carefully worded sometimes and far more scrutinized. Because if you go outside of court and you start making statements about people, that could subject you to some sort of defamation lawsuit. But really great question, Kimmy from Maine, and I appreciate you asking it. All right, let's keep it moving.
Good morning, Courtroom Confidential. Joshua, Tiffany, and Kai. This is Simi, like Jimmy, like Kimmy. One day you'll get it right, Cali Guy. Anyway, my question is, I'm curious of the aftermath, the repercussions of the two high-profile cases, Spector and OJ. How did that affect the DA's office in the aftermath? Did it change things? Was it, since it didn't go the way you wanted, just wondering if it really messed you all up or if it was changed things. Yeah. Okay. Anyway, love y'all so much, and know this, if I don't make the lives, I definitely am the rewatch crew. Always and forever. Love y'all. Bye.
Thank you so much, Simi. She gives me a hard time because she says Cali boy, because here we have Simi Valley spelled the same way. So every time I see her name, I think of Simi, not Simi, but it is Simi. And where are you from, Simi? That's one thing that's missing. But I love this question because it asks about the aftermath in the DA's office, with especially here in Los Angeles, where some of these really high profile cases did not go well for the LA DA. And I will tell you, it has a huge impact. When I was a young DA training in the office, we talked about these cases. I mean, there are fundamental changes in the way that they handle certain cases because of the impact of some of these cases. OJ probably being the biggest amongst all of those. But it starts actually before that with the Menendez brothers. So here's just a little history of the catastrophes of the DA's office. First of all, the Menendez brothers, huge case. By the way, as far as like high profile cases, it's hard to understate how big a case this was because basically Court TV got started with this case. So huge case, followed every single day, highest profile case, as high profile as they get. In January of 1994, at the time, consider too, the social climate was that these were the most guilty of kids, and they're bringing this defense that everyone found to be laughable, and this should have been a slam dunk for the DA's office. In January 1994, there's a mistrial declared, and that is seen as a huge loss by the DA's office. How could they lose this case? They admitted to the murders. They admitted to it. They got on the stand and admitted to it, and you're telling us you still lost this case? Then, not lost, but mistried this case. Before that case goes back to trial, a person by the name of O.J. Simpson is arrested for the murder of his ex-wife and a waiter. That case gets an acquittal in October of 1995. So within a couple of years of that taking place, then you have the largest loss probably ever experienced by the LA DA's office with the not guilty of O.J. Simpson. Then the Menendez brothers go back on trial and they are convicted. But then flash forward just a few years later, another huge high-profile case with Robert Blake. I don't know if you guys remember this one, but he was charged with the murder of his, I think it was his wife at the time. And there was this kind of ridiculousness of where he left his gun in the booth of the restaurant and he had to go back to the restaurant to get his gun. And when we came back out, she had been shot in the car and everybody thought slam dunk of a case. He walks acquitted, not guilty, March of 2005. And then a couple of years after that, another huge case, Phil Spector, cameras in courtroom every single day. The guy walks out of a house holding a gun and says, I think I just shot her, or says, I just shot somebody. Again, what all people may have considered a slam dunk of a case, but it's in LA and it's involving a celebrity and it's the LA DA's office. And can they bring this home? And in September of 2007, there's a mistrial declared on that case as well. Now, we came back in 2009 and found him guilty, but there was the string of these high-profile cases where involving celebrities where it was like, you cannot convict a celebrity in Los Angeles. And maybe that's an unfair assessment given, there's plenty of cases they did get convictions, but in these high-profile cases, it seemed like they were having trouble. So to answer your question, Simi, it has left a huge impact, and the way that they handle these cases are very different, and they are very, they've created entire units just to handle these high profile cases. The best of the best are put on them. They're treated with absolute seriousness. And, there's kind of no messing around with this stuff anymore when it comes to jury selection and everything else. But I will say the reverberations of these cases still kind of echo through the walls of the DA's office. So thank you, Simi, for that incredible question. And thank you always for your support and for calling in. All right, let's keep it moving.
Hey, Josh and crew, this is Sue from North Carolina. I noticed recently in the news that with the Idaho 4 Kohberger case, that the scene of the crime, that home was demolished. And I know they've created 3D models and things like that. I've also heard recently that the Gilgo Beach Rex Heuermann home is being emptied out and likely either sold and or demolished. I'm just wondering who gets to make those decisions in those cases. Those were private homes. There's a homeowner. What say do they have in that? And then who really gets to make the determination on whether or not that crime scene can be changed, demolished, gotten rid of? Who's involved in that and what goes into that? Thank you.
Thank you so much, Sue from North Carolina. Put it on the map. North Carolina, thank you so much for calling in. I agree with you. I don't even know if you said that you don't like it, but you're asking the question, and I think by asking the question, you're saying you don't like it, and I agree with you. I have a real issue, especially in the Bryan Kohberger case, that they demolished the home here, because I feel like the home is going to become a significant part of this case. A lot of it had to do with what people could hear, where people broke in, where people were positioned, why other people didn't wake up, how the alleged perpetrator knew where to go and where people were sleeping. All of this stuff, the home, the layout of that home, the acoustics of that home are all going to play a role in this trial. And they have done all sorts of 3D rendering and maps and everything else. I'm still bothered by the fact that they tore it down. The Rex Heuermann home, she brings up that they plan on demolishing that. I don't think it's been done, but they plan on doing it. And the question is, who makes these decisions and how are they allowed to do this? The answer is, first of all, doing a jury view of a location is not very common. It's rare. But in certain cases, especially high-profile cases, they will ask for it. And I think the Bryan Kohberger case would likely be a case where they would ask for it. Now, that was made much more complicated when they moved the case from Moscow to Boise, which is a several hours trip away. So the logistics of doing all of that probably went out the window. And they probably thought, well, we're not going to have a jury view anyways, so let's make sure that we document this as much as possible. And then if the owner wants to do with it what they want, they can go ahead and do it. From a legal perspective, like, they would have to seize that property from that person. They would have to seize it as evidence. Now, can they do that? Sure. Is there a reason for it? Also sure. Maybe they didn't want to enter into all the trouble of the litigation and everything else. But I am a little bothered by the fact that I just don't want this case to go poorly, and I don't want there to be some issue that could have been avoided that creates an appealable issue. But that's where we're at. Sorry, what was that? First time seeing your channel from Kosh, Ohio. Thank you so much, Carolyn, and thank you so much for the support, and we hope that you stick around and come back. And leave a message at thecourtroomconfidential.com so that you could be a part of Sunday Fun Day. But great question, Sue. And I'm right there with you. I don't get it. I think they could have avoided it. It wouldn't have taken all that long, but they didn't do it in this case, and I hope it doesn't cause problems. Let's keep it moving.
Hi, Joshua. This is Fauna Eastep in beautiful Coeur d'Alene, Idaho. Just want to say, first of all, I love your program. Watch you every chance I get, and I will continue looking for new stuff that you put out. My question for today is in regards to the Lori Daybell trial. And my question is, will the prosecution be able to introduce a continued conspiracy with Alex because of the convictions that Lori has here in Idaho, somehow introduce it, tying it together so that they can show that there was definitely a conspiracy between the two? I would think that would make sense. And if they're not allowed to introduce it, why not, since it seemed to have begun from here in Arizona, the case here. And I'm just really curious if that's going to be able to be introduced to the trial. And just really enjoy your show. Thanks a lot for taking the time out and answering questions.
Fauna from Coeur d'Alene, Idaho, put her on the map. First of all, Coeur d'Alene is gorgeous. I had family who lives and still lives there, I believe. Beautiful place. Thank you so much, Fauna. And Fauna, I got to tell you, I love this question. I love this question because you thought about this issue so creatively and in a way I had not even considered it. So Fauna's question, by the way, hand out a trophy to Fauna. Fauna's question was, in the Lori Vallow case, the case is about proving a conspiracy, and the prosecution is not allowed to bring in her prior convictions and the prior murders that she is convicted for in Idaho. And I think that's the proper ruling. We do not, in this country, convict people for who they are or what they've done in the past and their character. We convict them for the crime that they're accused of and whether or not there's evidence to support that. So we don't want evidence of these ghastly, nightmarish murders being the reason why they convict her of a crime here. We want it to be based on the evidence of the crime here. But Fauna cleverly says, well, in a conspiracy, might that add to the conspiracy? In other words, because there was an ongoing conspiracy that continued as they made their way from Arizona to Idaho, and she continued her path of destruction and murder. Wow. That's a great argument. That if you are questioning whether or not Alex Cox and Lori Vallow were involved in a conspiracy together, then I present to you what they continued to do when they went to Idaho and continued to kill 2 children and a mother in Idaho in furtherance of their ongoing conspiracy. I love that argument. Will it have changed the judge's mind? Probably not. Probably not. And so, because it's still so highly prejudicial for this jury to learn about this, these murders, but it is a very clever way of trying to ask for that to come in. But Fauna, she could absolutely open the door to this stuff. If she testifies and says something along the lines of, I've never done a thing in my life that would harm another person, and I've never been a part of anything that would harm another person, and I've never conspired to harm another person in my entire life, well, then obviously that's going to open up the door to everything she's ever done. But even if she asks some kind of overreaching question, if she asks some investigator that isn't it true, sir, you have no evidence of any conspiracy between me and Alex Cox beyond these text messages that you've shown us here today? Well, actually, yeah, we do. We happen to know some things that you were up to in Idaho. Would you like me to elaborate? So she could absolutely, and if she's not careful, open up the door very easily to other conduct, especially if she were to testify. And that there's a good question about whether or not it even comes in regardless if she testifies. But great question, Fauna. Really, really appreciate you asking that. Run the World says, gotta go. Thanks, Josh. Love your show. Cheers from Encinitas, California. Thank you so much, Run the World. Appreciate you being here and appreciate your support. All right, let's keep it moving. Hold on. Got to refresh.
Hi Josh, it's Jude from the UK. My name on YouTube is Jadzia1969, but I'm going by Cannoni's Baloney at the moment for the Karen Reid trial. I watched the Ingolf Tuerk trial and noticed the prosecution attorney Lisa Beattie and Kevin Reddington seemed to get on really well. And you could sometimes even hear her laughing good-heartedly when she made objections. I wondered if you've ever found yourself opposing a friend in court, and if it was at all uncomfortable. Thank you.
Jude from the UK put her on the map. Thank you so much for that call and question. And I love this question too, because this stuff does arise. Listen, as much as I said how big the DA's office here is in Los Angeles, the criminal community is actually not all that big. The criminal community, the criminal lawyers community, the criminal community in LA is pretty big, but the lawyers who handle those types of cases, the community is actually rather small. And you do kind of know, I know most of all the criminal defense lawyers in LA, and I know most of all the prosecutors, and you just kind of run across these people. So she references, Jude does, the Ingolf Tuerk case, and the prosecutor, Lisa Beatty, I hope I'm pronouncing that right, Beatty, and defense attorney Kevin Reddington seemed to kind of get along in court. And there was kind of some joking and some I don't know what you want to call it, happy back and forth between the two of them, friendliness between the two of them. And how common is that? And, pretty common. I mean, it's funny. When I was in criminal practice, we always talked about how in civil practice, it's not civil. In civil practice, it seems like the attorneys hate each other, and the interaction between attorneys is awful. In criminal practice, you get along with these people fairly well. And I think it has to do with you are just dealing with things of such incredible magnitude that it's like, why are we fighting each other on top of all of this? Now, that doesn't mean that you don't get down to it and you don't get zealous on either side. But afterwards, you're not making it personal. You don't hate this person. Now, that doesn't prove true across the board. And I have some attorneys that, I'll walk by in the hallway and not share a glance with them because we don't entirely love each other all that much. But it is not uncommon to get along really well. And in fact, when I was a DA, I got along with a lot of the defense attorneys really, really well. And I share the same kind of thing when I'm on the defense side of things. And she asked, have I ever had I've been a civil litigation clerk since 98. Some are not civil. That's so true, says LA. Have I ever gone up against a friend in court? Well, if they're a friend, they would likely have to recuse themselves if I'm on the defense side of things. Defense never has to recuse because we have a client who has a constitutional right to an attorney of their choice. But I have had cases where prosecutors have had to recuse themselves because we have a closer relationship. I've had cases where judges have had to recuse themselves. I've had cases where judges have had to explain that they know Mr. Ritter and have, shared a cocktail with Mr. Ritter here or there or something like that. But I did have one case when I first left the DA's office, and it was one of my first defense cases, and it went to prelim. And the person who was the prosecutor was a friend of mine, but no one felt that it rose to the level of a conflict. And my client didn't have a problem with it, and he didn't have a problem with it, and the judge didn't have a problem with it. But this is a good friend. And because of that, the entire courtroom was full of all of our friends from the DA's office because they all wanted to come down and watch Josh and Scott go at it together, because it was like, oh boy, Ritter's back. And now he's a defense attorney. I mean, this was like within months of leaving the office. So I just had my going away party, and now I'm back in court on the defense side of things. And they all wanted to come down and watch it. And so it was pretty funny. And I was giving him the business, and we were having at it. And we were even joking during breaks that I was not giving him much of anything. And I felt like I was scoring points and doing well and chopping up the investigators, and boy, oh boy, am I lighting the world on fire here. And then we got to a point where I was cross-examining one of the investigators, and I felt like there were all sorts of holes in their investigation. And then he says something along the lines of, well, that was addressed in my supplemental report. And I go, huh? And I'm looking through my file, and I'm looking over at the law clerk I had with me, and they're looking through their file, and we go, what supplemental report? And I turned to Scott, and he goes, this supplemental report. And I go, well, I don't have that. And in that supplemental report, they had cleared every issue that I thought existed in the case. And I turned to the judge and I go, Your Honor, this is a tragedy beyond tragedies. This is late discovery. I've never been handed this report. And the judge says, I agree with you, Mr. Ritter. How much time do you need to review that before we come back? And I said, I need 60 days. And she said, I'll give you till tomorrow. So I went home and I reviewed that report, and it shut down damn near every argument that I had in that case. And the next morning I came in and I talked to my client and I said, by the way, they've made us an offer and it's not that bad, and I really think you should take it. So that's how that whole thing ended up. But great question, Jude. And yes, we have gone up against friends before, and it usually ends up in us still being friends. Not quite 60 days. Correct. All right. Let's move it along here. Let's keep it going. Let's keep it rolling. Let's fuel up our jet and see where we're landing next.
Hi, Josh. My name is Jenna. I'm calling from Toronto, Canada. I don't understand why society has given Lori Daybell latitude to be her own lawyer and for this trial, because she's already serving 3 life sentences. I think it's just like a vanity project for her. I guess people are making a ton of money off it, but I think we're just feeding into her insatiable desire for attention. And why isn't she deemed, like, why isn't she in a loony bin? Because she's been diagnosed as delusional with religiosity and narcissism disorders and stuff. I shake my head and I don't like want to pay attention because I don't want to feed into that whole Lori show. It's just so depressing, and it's a disrespect to the victims. Okay, thank you. Bye.
Thank you so much, Jenna from Toronto. Put her on the map, Toronto. Thank you again, our friends from the north. Again, great. I get it. Why everybody's like, what are we doing wasting more time on Lori? Again, the financial thing, I don't know if there's anybody making money off of this. Maybe you could say, YouTubers or something are making some money off of this, but I don't think anybody's really making money. There's no real profit to be had here by putting Lori on trial again. I think this really has to do with the people of the state of Arizona saying, hey, by the way, you killed somebody here too, and you should pay for that. And I realize you're going to spend the rest of your life in an Idaho prison, but that doesn't mean you don't pay for what you did here. But Jenna's question is kind of like, well, okay, well, fine. But on top of that, why are we allowing this spectacle of her to represent herself and her to turn this whole thing into a circus? And that's also an interesting question. Where does this ability to represent yourself come from? Well, it comes from the 6th Amendment. You have a 6th Amendment right to counsel. But the Supreme Court has viewed that, and this is how constitutional law works. The Constitution is not elaborate. Some of these amendments are one sentence long. And so out of one sentence, we've had decades of jurisprudence and common law decisions to decide what does that one sentence mean. And it will expand it or contract it. And in the case of Ferretta versus California, decided out of 1975, they decided that that right to counsel also includes a right to self-representation. That read into that doesn't just mean you have to have counsel, but your counsel can be yourself. The quote that came out of that case, first of all, let me give you a little background on Ferretta. He was accused of grand theft in California, and he wanted to represent himself because he felt that the public defender's office was overwhelmed. Not an uncommon problem and not a bad reason to want to represent yourself, by the way. But it was for grand theft, and the judge denied him that because the judge felt, I'll be honest with you, the judge probably felt, I don't want to deal with this nonsense. But the judge said, well, you didn't answer questions about what hearsay is. You showed a kind of a lack of understanding, even though Ferretta had represented himself previously. And I'm not going to allow you to represent yourself. And what's interesting about this and why I bring up the facts of that case is even these small cases, Ferretta was likely served his time and got out before this ever even made its way to the Supreme Court. But even in these small cases, you can have precedent that is hugely impactful. And I all the time, we would talk about Ferretta waivers and Ferretta rights when I was a DA. And it comes back to this case for a guy who's, probably stole $200 worth of, I don't know what, widgets from some building, and now he's on trial. Now his case is a Supreme Court case that establishes a right for self-representation. But this quote came out of that case that I really enjoy. It says, "To deny a man in the exercise of his free choice the right to dispense with some of these safeguards," meaning the safeguards to a right to counsel, "is to imprison a man in his privileges and call it the Constitution." I loved that. In other words, we cannot say we're going to force a right upon you and call it constitutional. You have a right to waive that, and you have a right to self-representation. So you can thank Mr. Ferretta and the Supreme Court in 1965, Jenna from Toronto, for why Lori Vallow is clogging up your airwaves and still driving you nuts to this day. All right, everybody. We are there. We are at our final question of the day. Where are we landing next?
Hey, everybody at Courtroom Confidential. This is Holly in Houston, Texas. And I apologize. I sound a bit different than normal. My family's been sick this past week, and now it seems I've got it, plus in addition to my other everyday things. So prayers appreciated. This is regarding the trial of Victor Hernandez Martinez. He is the illegal immigrant who was caught. Actually watched him being captured over on the interview room. They have a great playlist, by the way, as does Grizzly. So y'all should check both of those out. Chris and Karen have also had Rachel's family on a few times for interviews. So if y'all like deep dives, and I think you do, then yeah, you're welcome. Okay, so local news channels to the trial, which began the Thursday before last, the jury was seated. They're posting on YouTube these 2 to 4 minute clips of actual testimony from the trial. However, nobody is streaming it. And I know that there's cameras because they're posting clips. I'm like, they got to be getting it from somewhere. So can you please help? I have tried Googling. I have tried YouTube. I have tried, all that I can think of. And I'm coming up empty, and I really want to see it through. So any help that you can offer is appreciated. Thanks.
Oh, I love hearing from you, Holly. Thank you so much. Holly from Houston is our final destination today. We've gone all over the world, and look at that map. I love to see it. First of all, Holly gives a shout out to the interview room, which I would like to do as well as to Grizzly True Crime and Gizla. If you want deep dives, you can't go any place better. And I think even Gizla might still be in the chat. So if you are, thank you so much for still sticking with us, and big shout out to Grizzly True Crime. Johnny Knoxville says, "You rule, Josh. Keep up the great work." Thank you, sir. Thank you, Johnny Knoxville, for being here. And there's Gizla. Thank you so much. Yes, you want deep dives, you want to learn about Rachel Morin, that's where you go to. And this is if you guys are not familiar with this case, it's about as tragic as it possibly can get. There is Rachel Morin. She was 37 years old. She's a mother of 5. She went for a jog in a kind of a popular trail called the Ma and Pa Trail in August of 2023, and was never heard from since. By August 6th, a few days later, her body is found along the trail. It has been badly beaten and likely assaulted. And this opened up a huge manhunt. And you remember this case because it went, the person was a fugitive for a long time. The police were asking for help. There was evidence that this person had also been involved in a home invasion, sexual assault in California, where there was some videotape that kind of showed this person. It was one of these, the FBI got involved. In fact, we did a whole case notes deep dive on this that we can include in the notes and comments that talked about this manhunt. It was an incredible manhunt, how they pieced this together to be able to finally find this man, Victor Hernandez Martinez, and track him down after months. And he is now on trial, and they are looking to bring some justice to Rachel Morin. And Yeah, I'm so glad they were able to catch this person too. It was a nightmare what happened to her, and the more this trial plays out, the more nightmarish we're finding out it is. But Holly asked, "Where can I find this? Where can I watch this trial? Where is it streaming?" And maybe Gisela, or anybody else, I need some help because we looked long and hard to answer this question. I can't find it anywhere. And I found some articles referencing how the judge may have been shutting down some media access and that there was some pushback from the media. I've heard some responses that the courtroom isn't that big and therefore doesn't allow for cameras. But then Holly makes the point that I've seen some clips, so there must be cameras. Where can we find this? So I am asking all of you wonderful folks listening, let's kind of crowdsource this question. If you know, and Vesper Martini says it's not being streamed, I'm confused. Judge said no streaming. Maybe that's the answer, and that is frustrating if true. Here we go. Gisela says, yes, the judge isn't allowing streaming of this trial. Well, that's unfortunate because it is a case of high importance and significance. And so I don't know where that video is coming from that you're seeing, Holly, but for some reason, they're not allowing this case to be streamed. So that is unfortunate. And that is our last question. Do not go anywhere because I have some big news for you guys. Some announcement of something that we have been working on here at Courtroom Confidential that I want to share with all of you because we are excited about it. But first, let me give you some quick announcements about some of the programming that we already have. First of all, yesterday was our weekly roundup. Please check that out. This is our weekly kind of check-in on all things true crime. We talked about Lori Vallow. We talked about Bryan Kohberger. We talked about Ingolf Tuerk. That is on our channel now. Please check it out. Last Monday, we had a very special presentation of our Case Notes series. It is one of our more popular videos now. It was on the Idaho 4 murders and Bryan Kohberger. We put a lot of work into it, sat down with an interview with Kevin Fixler. We're incredibly proud of this video. And Kaylin, I got to give another shout out to Kaylin for the tremendous work that she did on this video. It's really something special. So please check that out if you haven't already. Stay tuned. This Monday, Esther Ludlow is going to sit down for our conversation series. She is from the very popular podcast Once Upon a Crime. She's one of the OG podcasters. Please check that out. We had a wonderful conversation that will premiere on Monday at 5 p.m. Pacific, 8 p.m. Eastern. Vesper says that was a great show. Thank you for the shout out, Vesper. Tuesday. Okay. This is the big news. This is what we want to announce for you guys. How do I do this? This Tuesday, we are announcing that we're starting a new channel called Courtroom Confidential Live Trials. Here's the thought behind this whole thing. And I'm going to show you where to go, if I can figure this out, where to go to find this. Right now, the channel it's up and live, right? Yes. Okay. So there's nothing there yet, though. But if you go to, and it's a little hard to find because we have not posted anything to it yet. But if you go to, the handle is called CC Live Trials on YouTube. Go there and subscribe now if you have a chance. And this is the concept behind this. We wanted to create a space for everybody in the Courtroom Confidential community to know that they could go to watch the trials live and just be streamed. So we thought, rather than, people finding some other place and maybe not being in the chat with people that they enjoy being in the chat with, let's just make a space for everybody to go to. So, starting this Tuesday with opening statements that are scheduled for on the Karen Read trial, we will be streaming that trial live every single day. We're going to try to be in the chat as much as we can. If I can pop in to provide a little bit of response and commentary where I can, I will absolutely do that. But this is not intended, at least at this point, to be one of those things where you can just sit and watch the whole thing with me watching it and talking to you about it. It's much more of a stream of the trial, and where we can, we will pop in here or there, but we just wanted to provide that space, and we hope that you guys enjoy it. So Go over to CC Live Trials as soon as you can and subscribe to this new channel. And starting this Tuesday, we will be streaming the Karen Reed trial. And I think the next plan is to stream the Kouri Richins trial if that ever gets started. But as these big trials come up and as they're streaming, you will have a place to go watch them. So we're very excited about this. It's still in kind of its beta form, and we'll probably be improving upon it as it goes along, but we didn't want to wait any longer, and these big trials are not waiting for us to kind of get ourselves together. So please go check that out. Again, that is a new channel. What am I doing here? A new channel. Yes, Courtroom Confidential Live Trials. Check it out. All right. What else do we got going on? Wednesday. Kevin Fixler is back. He's the gentleman that we interviewed from the Idaho Statesman that we sat down and did that whole Idaho, Bryan Kohberger case notes on. He's going to be back live on Wednesday night because there's been a bunch of new rulings in Bryan Kohberger. There were some last week and there will be some this coming Wednesday. So perfect timing. Join us Wednesday evening, 5 p.m. Pacific, 8 p.m. Eastern, to talk about more Bryan Kohberger with Kevin Fixler, who's been following this case from the very beginning, and he's fantastic. And then, sad face. Next Sunday, we will not have another Sunday Fun Day, because next Sunday, you should be out in the yard chasing down some colored eggs with your kiddos this coming Easter, and that's what we will be doing. So we thought, let's take that Sunday off, and we will be back again with more questions. Please leave us the questions in the meantime. We will get to as many of them as we possibly can. But no courtroom or no Sunday Fun Day this coming Sunday. In the meantime, you guys are all fantastic. I appreciate all of your support. If you want to know, how do I keep doing this? If you want to know where to find more about what we've got going on in Courtroom Confidential, go to thecourtroomconfidential.com. You can become a member up here and learn about all the benefits that there is to membership. You can click on send us a voice message, and that's where you can start recording your voice messages for Sunday Fun Day. You can go to the shop and see all of the new stuff we got coming out, including this t-shirt, which will soon be up on here. But this is the one-stop shop for everything dealing with Courtroom Confidential. In the meantime, you guys have been fabulous to stick around with me. We appreciate you all. This was a real fun Sunday Fun Day. We traveled the entire world and we got some incredible questions. You did not think that you would be talking about the Menendez brothers, along with Lizzie Borden, along with whatever other craziness, Donna Adelson and Kouri Richins and Phil Spector and all of the other stuff that we jumped into this week. Thank you guys so much. Could not be doing any of this without you. Appreciate you all. I hope you have a wonderful rest of your Sunday, and I'll be talking to you all soon. Take care, everybody.